Welcome everyone. Just a formal sort of opening, and then I'm going to do a more conversational opening. So I'll start the hearing. This is a properly convened meeting of the hearings panel, called for the purpose of hearing submissions in relation to the resource consent application by TKO Limited for a development at Rocky Point. I'd ask the Minutes Secretary, Ms. Smith, to report on proceedings to date.
All statutory requirements under Section 95 of the Resource Management Act have been complied with. The Section 42A report prepared by the Planning Officer has been circulated to address for service and all submitters. The submissions received have been identified in the report.
Thank you for that, Smith. All right, on behalf of the Central Otago District Council Hearings Panel, I'd like to welcome you all to this hearing on the proposed development at Rocky Point. Before we get started, health and safety, I'll just ask you, Karen, to just advise what that procedure is.
Yeah, so we have the fire exit just here to our left, your right. If there is a requirement to exit, if you need bathrooms, it's just out through this exit door here, and then just to the right if you need bathrooms.
Thank you. My name's Gary Ray. I've been appointed by the council to chair the council's hearing panel in the absence of the chair, Neil Gillespie, who was unavailable. I've performed this role on a number of occasions before. Just a brief introduction. I'm a planner with 40 years experience, 20 years as a hearing commissioner. I'm a fellow member of the NZPI and I'm certified as a hearing commissioner with chairing endorsement. I'm based in Tasman District, but most of my work has been further south, including here in Central Otago. Now with me on the panel to my left is a person. You want to introduce yourself?
Good everybody. I'm McPherson. I'm a district councillor. I've been a commissioner for too long, for about 20 years now. So enjoy this role that I have within the council, and I must say I'm looking forward to this hearing, and I will go home and plant a couple of more trees to for this mammoth amount of paper by the funds.
I'm Ian Cooney from Central Otago District Council and I've been on the hearings panel for 2 years.
Thank you, gentlemen. Now we'll just do a roll call at this stage, I think, just to see who's in the room, and Ms. Smith will busily take down notes. So we've been through the panel. We'll just start around this side actually, because we've got the reporting officer there.
Good everyone, I'm Ian Person, and there's the Commissioner said I'm the reporting officer on behalf.
Thank you. Mr. Gardner.
Shannon Garden, services to TKO properties and coordinate the finance application.
Thanks, Mr. Gardner. You?
Yeah, Tim Sullivan. I'm representing the application here today on behalf of TKO properties. You'll be farming from the area and taking the development on site. So, yeah.
Thank you. Thank you.
Again, so council for the applicant.
Thank you.
Being Grayson, also the council for the applicant.
Thank you. And while we're on the applicant, we'll go down to the back of the room and.
I'm Paddy Baxter.
Yes.
Let's get back.
Thank you. Thank you, Mr. Baxter. Okay. Mr. Beale, I see there. Is it? We'll just do a quick introduction and we'll make a note of who's here at this stage. Right, okay. So,
Andrew Wells, ecologist representing TKO.
Mr. Wells, yep. Okay. Anyone else? Mr. Jeff Brown. Thank you.
Jamie Cowan, wildlife official.
Thank you, Mr. Cowan. Thank you. Right. Okay, fine. Thank you. And we have some department witnesses here.
I'm the council of construction.
Thank you.
Kia ora, I'm Liz Williams. I'm our independent inspection.
Kia ora, Richard Ewens. I'm the technical ecology for the ecologist.
Thank you everyone for being here, and we will have some others joining us on Zoom or Teams during the course of the hearing. Right, just in terms of procedure, this application was lodged and notified some time ago. It was placed on hold at the applicant's request in order for the applicant to be able to respond to submissions and matters raised in submissions. As a result, a revised application was lodged, which the panel determined was within the scope of the application as notified. And that revised application is what we'll be addressing through the course of this hearing. Morning, Ms. Lucas. And I'll just make the point that it is the revised application we're considering, and there are a number of comparisons have been made to the application as lodged, but essentially it's the revised application, and we're considering the change to the environment to what's proposed in that application. The panel has issued 4 minutes to this point in dealing with procedural issues, hearing arrangements, etc. And we have signalled expert witness conferencing may be directed on ecological matters. It's also possible we may direct expert conferencing on landscape evidence as well. So I would just signal that at this point we have opposing, if you like, landscape evidence as well. And before we move on to the hearing schedule itself, does anyone wish to raise any sort of procedural or early matters at this stage? Okay, we'll move on. We have an indicative hearing schedule, which you may have in front of you. I think Ms. Lyons was at great pains to point out this is a fluid schedule, and we've endeavoured to give some certainty, but we're just not sure how long it will take. So I'm pretty confident it will go into the third day, including the site visit by the panel. At this stage, we've got the applicant taking up, using the whole of today and the morning, most of the morning tomorrow, which is what we expect, with submitters in the afternoon tomorrow. And we intend to get through the submissions tomorrow. So if we have to stay a little bit later, we'll do that, because we appreciate people may have to leave and get back to their hometowns. And we've currently got lunch down for 1 hour. We could shorten that, but we were conscious that the applicant and witnesses and submitters may wish that time to organise themselves, but we'll keep that on hold. We may actually have reduced lunch breaks if we need to. The other aspect is it's possible that it might be a bit showery on Wednesday morning, just keeping an eye on that. So it is another possibility that we could do the site visit tomorrow morning. If that happens, it won't affect the submitters. It would just mean that Mr. Brown might present to us on the third morning instead of tomorrow. So we'll just keep that one parked for the moment and see what progress we make through the hearing. Just about there. In terms of the substance of the hearing itself, you'll see on our desk there's a lot of material. For instance, this pile here's got some 2,000 pages, and I think there's another 1,000 and close to 1,000 in evidence. So I just want everyone to be aware that we have endeavoured to read that, and I've spent several days on it myself. But please don't assume we're totally au fait with everything in there. We're interested in contrasting evidence and finding commonalities and finding areas of difference. So when the witnesses are presenting, if you can just keep that in mind, that we're principally interested in the differences in opinion. We do need to know the detail as well. So it's a fine balance, and it's a difficult job, but we do appreciate the effort that's gone into producing this material. There's some very good evidence in there. And then in terms of, I often do this at a hearing, some preliminary comments. We've read this material. There's probably 3 or 4 issues that I'm certainly going to need some help with, and the rest of the panel may as well. And I'll just go through those quickly in case it helps. One of the key things for me is the origins of the recreation zone. We've got a very defined zone boundary with ONL. I'm not clear. I know it came from the Vincent County scheme, but I'm not clear how that was derived and how much work went into preparing that zone and how defined the boundaries are, or how particular they are, how important those boundaries are, I guess. That's the first one. The second one is the NPS, Indigenous biodiversity. We've got a range of evidence on that. I understand this site is not listed as an SNA in the district plan, but the evidence seems to be that the vegetation on the site would qualify under the criteria for determining an SNA. And what we're interested in, where that leaves us in terms of the legislation. What are the implications of mapped versus unmapped SNAs? And I know the Department of Conservation's got some evidence and possibly legal submissions on that, and the applicant will as well. Another one is the architectural heritage items, the relationship between the New Zealand HPTA and the district planning role of the council under the RMA. That it seems we need to be clear on what those distinctions are. From reading the evidence, I'm not totally clear on that. Another one is the contract management services agreements, which Mr. Garden will take us through, how these work in an RMA context, experience in other areas, and how they're weaved into conditions and monitored, enforced, etc. And then finally, the final sort of issue I'd flag at this point is the conditions themselves. Need to go through those in some detail with Mr. Brown and Mr. Vincent. And just to alert the participants in the hearing that discussions on conditions we have not made up our mind. It's something that has to be done. If we're in a position to grant consent, we need to know those conditions will work. So don't read too much into any discussions we have on those. So sorry that's taken a while, but there's a lot of material to get through. We best get started. But thank you everyone again, and welcome to this hearing. And I'll now hand over to the applicant.
Thank you, Commissioner. Thank you for your very warm introduction. That's always helpful to get a preliminary kind of observation on what will assist you in the decision making. And I think of those 5 methods that we put down, we went through almost all of those in our discussions. So I'll take time to pinpoint to those if we work through them.
Yes, and we haven't seen these, so that just take us through gently. And
yes, absolutely, sir. So we've got about 37 pages of legal submissions, and we'll absolutely take you through those gently. But given the timing, might also do a bit of a light touch on
sure.
non-controversial aspects of the legislative regime under which we'll be making decisions.
Sure.
So if we crack into it, and I'll also just say in terms of housekeeping, I think for ease, I'll probably just present the submissions, but Mr. Beeson and I probably answer any questions together.
Sure.
This is being joined with it. And similarly, because of the nature of the evidence being quite interlinked in terms of across different environmental domains in the law, there might be some questions of us that we may need to defer to witnesses or take a bit of a team approach to answering, but let's see how we go.
All right, no, that's fine. Thank you.
So in terms of the page 2, just setting out kind of how the submissions have been structured, we'll start off with a bit of an executive summary and an overview of the decision-making approach, then into the 4 kind of legal principles. And I think that's important because it sets up, I guess, the ability for you to step back and understand how to apply quite technical evidence. So we've done that first. Then from page 66, so about the middle of submissions onwards, we start to dive into a little bit more analysis in terms of the legal evidence. And I hope that will assist your point about sort of really trying to understand where the differences lie.
Thank you.
So while we're happy to answer questions on the way through, it might also assist to hear both of those component parts if this happens first. But we'll be guided by you on that.
We may interrupt you from time to time.
Absolutely, certainly, yes. So starting at page 3, I think we can probably take that mostly as read. You've introduced the proposal, obviously, and I agree with that. We are here to assess the revised proposal as it's been submitted as it stands today. I haven't tabled an updated set of conditions with these submissions. Those will be tabled in Mr. Brown's summary statement. And as is usually with these proceedings, there might be a little bit of iteration as we work through those conditions as well to hear the evidence.
Just on that, is there another version that you've developed since Mr. Brown's evidence?
Mr. Brown is working through some tweaks.
Okay.
But there's no revised scheme plans or such that we're tabling at this point. So
okay. Thank you.
They are really matters of detail.
Right.
Okay, so starting at page 4 then, in terms of the executive summary, paragraph 5, it's our submission that the applicant's proposal will ensure overall no more than minor effects will occur in terms of landscape and visual amenity, servicing, traffic and transport, fire and hazard risk, and archaeology and heritage. Applying a carefully prescribed ecological management regime, including biodiversity offsetting in accordance with the NPSIB, the application will ensure an overall net gain in Indigenous biodiversity values. In consideration of the CODC operative plan as a whole and undertaking a structured analysis of the objectives and policies in a proper context, the proposal will not be contrary to those plan provisions. In light of this, the application can pass both gateway tests for a non-complying activity under section 104D. And moreover, the overall effects of the proposal, when assessed under section 104(1), are considered to be appropriate and net positive. So an important starting proposition for determination of this proposal is that the site as it stands today is not protected, does not protect important Indigenous biodiversity values. This is because the ODP precludes the land rules as to Indigenous vegetation clearance. The ODP permits farming and viticultural uses which could have significant adverse effects on Indigenous biodiversity. And the private covenant between the landowner and the Minister for Conservation does not provide meaningful protection through prohibitions on Indigenous biodiversity destruction. The document as lodged and the section 42A report writer have failed to look at the proposal at that first principles kind of proposition. We submit that when looking at the current under protection of the site compared to the benefits of the proposal, which will actively protect the significant majority of the site in perpetuity, the effects overall are overwhelmingly positive. The submitter and council positions are undermined by their failure to factor in that permitted baseline for the site, which could quite likely result in far more significant adverse effects on Indigenous biodiversity than unification. A failure to take account of this baseline when making determinations in the proposal could result in perverse outcomes contrary to Part 2 of the Act and the NPS itself. The application overall is highly unique in that it is fundamentally designed around an underlying development right in the development zone within the site. A detailed and technical review of the site as a whole has resulted in a more suitably integrated development proposal, having regard to all environmental effects than that which could otherwise be envisaged by stringently staying only within the development zone footprint and achieving a controlled activity consent. Since lodgement of the application, the applicant has significantly refined the proposal to respond to superb concerns and those of the 42A report writer. Moreover, the proposed approach to addressing Indigenous biodiversity effects within the site has been fine-tuned since lodgement in light of the relatively recent case law and guidance evolving under the NPSIB. Accordingly, we submit that it is appropriate in this case to grant consent to the application on the conditions proposed. Taking now to the site and environmental context, probably a light touch on this because that is well set out in Mr. Brown's evidence and the summary statement. Mr. Brown really set out kind of the background design approach to the proposal, I guess, in terms of where the proposal now sits. But I do emphasise that it is a complicated site and it is somewhat of a complicated proposal, and that's due to a need for balancing competing intricacies of landscape and visual effects, heritage and archaeology, Indigenous biodiversity, servicing and access constraints. And what I mean by that is saying, you know, when you look at the development holistically, it's not necessarily that easy to say, you know, shift something here or shift something there. There are flow-on effects in terms of landscape and visibility, for example. So it is all sort of quite interconnected. That's the thrust of that submission. In terms of the legal principles, so we set out there at paragraphs 15 and 16, as you'll be well familiar with, the principles of consideration under the 104D non-compliant gateway test. Those are twofold, the first being the minor effects test and the second being the policy test. And then if the proposal can satisfy one of the gateway tests, the decision maker must then consider the matters in section 104(1), which is in the round of assessment of effects and policy matters. At paragraphs 17 and 18 there, I just draw on it again, not particularly controversial case law about what the contrary to policy test means in section 104D, and the High Court has found that contrary to objectives and policies means something which is opposed to nature, different to, or opposite, repugnant, or antagonistic. it's our submission and the evidence of the applicant, that will demonstrate the adverse effects of the proposal will be no more than minor. And the proposal is not contrary to the objectives and policies of ODP. Accordingly, in our submission, the proposal passes both gateway tests. I also note there at paragraph 20, the very recent Supreme Court case, which you might be aware of, commonly referred to as Easley's Link.
Oh,
It was issued earlier this year, and again provides some quite interesting commentary on that orthodox section 104D test. But you can see there at paragraph 20, we've commented on the observation that that assessment of whether a threshold is passed does not take place in the abstract, but in the context of a particular project at issue. And that gateway test is really characterised as a preliminary assessment only, and whether or not the consents would be granted if the threshold is passed would depend on the outcome of the full analysis under that section 104 stage. So I think that that's quite helpful to sort of solidify probably what you already know, but yeah, from the Supreme Court. So I note that as a consistent theme of this submission, the contextual approach is particularly important. And that's again where I take you back to the starting proposition of the site being highly vulnerable or not well protected as it stands under ODP now. And I'll take you through why that is in a bit more detail soon, but that really comes back to the permitted baseline argument and what is actually currently protected on site at the moment or not. At 22 and 23, then we go through again relatively orthodox principles for assessment under that more holistic section 104 test. Now, section 146, we've put this in there at my paragraphs 24 and 25 in reference to a response really to Ms. Williams or the DOC plan evidence. So that evidence suggests that there are gaps in the baseline data, in particular for threatened and at-risk plants within the site. And on that basis, there's a suggestion that consent could be declined under section 106 of the Act for want of adequate information. In response, we say that the applicant, through extensive consultant expertise listed there, Ms. Simpson, Dr. Wells, Ms. Tockett, Ms. King, Mr. Gibson, and Ms. Beale, have spent considerable time undertaking base data surveys and documenting these in the evidence. This work has also been supported by further peer review input from experienced consultants. And we accept that doctors also invested considerable resources in the evidence, using a number of senior botanists who have also identified important biodiversity values within the site. So with all of that in hand, we suggest that it simply cannot be true that between those extensively experienced experts and the significant data and time taken to prepare the same, that the Commission is faced with inadequate information to determine the application. Rather, and I suggest this was characterised in your opening comments, that what is required here is an analysis to weigh and balance competing expert opinions in order to determine the effects of the proposal.
I'll just interrupt you there, just to discuss that point. It's the department's case that in the small amount of time they've spent looking at the site and looking at the species on the vegetation, that's alerted them to the fact that there's a lot of other information that's required. So your point here is that there's been a lot of hours spent on it, but their point is that that just leads to the conclusion that more work is needed to be done. So do you have any response to that?
Yeah, that's right, sir. So the observations were that important species were found that were not observed within the applicant's initial assessments. However, and I'll take you through this when I get to the competing pensions evidence, but the opinions of the applicant's experts are that that's not actually irreconcilable, and that the values assessed holistically as guided by the NPS are properly accounted for.
All right.
So yeah, it's not just a matter of time on site. Absolutely, it's the inadequacy of the analysis which comes out.
Thank you.
But I do take it back there at my paragraph 27 to, I guess, suggest that that approach is kind of a philosophical one, that no amount of data or investigation could be enough. And you know, the applicant has spent considerable resources on the site, a site which is sort of predicated around a development zone. Because of the increase IV coming out relatively recently as well. So then I think my next section will help you understand particularly what I've been talking about in terms of the fundamental starting point about what is protected on the site now. And this is where I talk about the permitted baseline. So paragraph 28, you know, as you know, in the application of the permitted baseline, in this case, is necessary and important in order to understand and assess the effects of the proposal on the environment. Now, the applicant's plan and Mr. Brown, as compared to Mr. Vincent and Ms. Williams, take quite different approaches to the application of the baseline. This difference appears to be a key factor underpinning differences of expert opinion. The applicant's proposition is that a landowner on this site could undertake any level of vegetation clearance under the ODP as of right. The only reason that consideration has been given to Indigenous biodiversity effects in this case is by virtue of the overall non-complying activity status, the triggered objective policy assessment, and the NPSIB as a result of the same. No rule as to vegetation and clearance per se is otherwise triggered. So that point is critical to properly have regard to when assessing the effects of the proposal on the environment and what the ODP deems to be permissible activities. The council officers and submitters failed to understand that in this context, the proposal is affording long-term and secure protections to these values, which will not otherwise necessarily be achieved. The purpose of the permitted baseline is to isolate and make effects of activities on the environment that are permitted by the plan or NES irrelevant. When applying the baseline, such effects cannot then be taken into account when assessing the effects of a particular consent application. The baseline has been defined by case law as comprising a non-compensable or credible activity that would be permitted as of right by the plan. That is a less exacting test than which applies to the receiving environment concept of whether a consented proposal is likely to be implemented. The logic of the permitted baseline is that if a relevant plan made an activity permitted, that represented a community view that the effects of that permitted activity were acceptable. Accordingly, a resource consent application for an activity on the same site should similarly be able to take those effects as acceptable. Mr. Vincent contends that there is no relevant permitted baseline, as no subdivision or residential activity can occur on the land as permitted. I submit that that approach conflates activities with effects. It seeks to disregard the application of the baseline by comparing the likeness of a permitted activity with a consenting activity. That is inconsistent with the philosophy of the baseline, which is an effects-based approach, not an activity-based one. Further, whilst the overall activity for which is sought, subdivision of urban platforms, is not permitted, and so far as Indigenous vegetation is concerned, the specific activity or the removal of vegetation is in fact permitted. This is regardless of whether the clearance is associated with a particular use. And I footnote there the specific analysis that Mr. Brown has set out on the ODP plans extends, which he can take you through as well. So in our submission, there are a few exceptions in case law where the baseline has been chosen not to be applied by a decision maker. As you'll know, you have a discretion under section 104 in applying the baseline or not. So case law guiding the baseline may not be appropriate to apply include where a baseline claimed by the applicant is fanciful or not credible, where the application of the baseline will be inconsistent with Part 2 of the Act, where the permitted activity with which the proposal might be compared as to adverse effect nevertheless is so different in kind and purpose within the plan's framework that the permitted baseline ought not be invoked. And that seems to be kind of similar to Mr. Vincent's issue. So we'll talk to that soon in particular. And where the application of the baseline would be inconsistent with the objectives and policies of the plan. So Mr. Brown has addressed the relevance of the permitted baseline again in his evidence. Of note, he's undertaken a very thorough analysis of the ODP to reveal that farming and viticulture activities on the site are entirely permitted and could have no corresponding limits on Indigenous vegetation clearance and earthworks. Mr. Brown has addressed the credibility of such activities occurring on the site with the owner, particularly in light of needing to generate a return on the investment in some form.
Just to interrupt you there, when you say the site, do you mean the whole site, not just the development zone? You mean the whole site, including the ONL? Okay, all right, thank you, thank you.
That's an important question though, because I think that we need to conceptualise the permitted baseline as distinct from the receiving environment, the latter of which addresses the relevance of the controlled activity consenting regime in the development zone. So slightly different constructs.
Yes.
Permitted rights by the plan, the baseline, consented, anticipated rights in a controlled activity framework, and just the development zone.
Yeah.
So I'll talk about the latter.
The vegetation clearance, what you've just said applies across, not just to the restricted parts of the site, but the whole site. Okay, no, that's useful. Thank you.
Yeah. And so we've just talked on that at paragraph 36.
Right.
This is different from, for example, a situation where the clearance was only permitted as part of a specific use.
Yeah.
So it actually takes it a step further, I think, when you look through Mr. Brown's analysis about how the site is actually precluded from vegetation clearance rules.
Okay.
However, in any event, it is imminently possible and not just sensible that farming activities through spraying or direct drilling or ploughing or tilling of exotic pasture as examples, or the introduction of viticulture on the site could be undertaken in a way that would have severe consequences on ecological values. Now, Mr. O'Sullivan and Mr. Garden will talk about those sort of conceptual farming or viticulture activities in their evidence summaries as well. So to give you a bit more sort of context on what is realistically credible. Applying a baseline in this case is entirely consistent with Part 2 of the Act and the relevant provisions of the ODP, because it will ensure an overall net positive biodiversity outcome as compared to any permitted farming or horticultural rights. It's not realistic to assume that the site will continue to sit undeveloped or unused in perpetuity. While the activity of subdivision and development are of a different nature to farming and viticulture, in our submission that is quite different from previous case law on this issue, and that the site does contain a development zone which anticipates a level of dense residential development of the site, coupled with exclusions of the site from the SMA and vegetation clearance rules together. So I suggest that there would actually potentially be perverse outcomes of not applying baseline in this case, which would result in an outcome directly contrary to Part 2 of the Act and the ODP. And that's because it would effectively signal to landowners that they should or could eradicate biodiversity values as a right under permitted rules. But they do not do so, and instead seek to protect those through a consent application process. They will not necessarily obtain the benefit of that comparison of alternative effect scenarios or the positive effect of protecting those, if you like. What I'm saying there is if the rule framework is not well protected against, undertaking permitted activities which have these adverse effects, we're often faced with the task of advising our clients, what should we do on the site to prepare for our consent application? And I guess the consequences, do you want to end up in a situation where landowners do not know whether they're going to get the advantage of a permitted baseline scenario and seek to protect or preserve those values until they get to a consent application, and then will have the benefit of cementing those through a covenant mechanism? Or do they, for want of a better word, crack on and do something so that they have a better playing field when they get to a hearing? That's the point of that. I also suggest a perverse scenario in terms of not applying a baseline approach would disregard the intentions and possible outcomes of the ODP as it stands today. That Indigenous biodiversity is actually not particularly well protected on this site. And again, I think it might help you if I take you through, when we get to the consequence of the SMA default identification under the NPS, which you've signalled, would be of assistance relative to that as well. So I'll take you through that soon.
And just on that point B, I think Mr. Vincent has said in his supplementary report that he acknowledges a conflict in the way the plan deals with the site. It allows vegetation clearance, but it also has protections in the ONL. So I think he identified a conflict there. And Mr. Vincent can address that later if I've paraphrased that. But that goes to your point B, I think, yes.
It's a good reminder. So applying that section 42A report approach to not use a baseline is, in my submission, not useful to prepare a farming activity to an activity that requires consent would be illogical and contrary to the fundamental approach of the baseline, which is a comparison of effects rather than activities. The importance of the baseline in considering competing evidence is further set out in our submissions in relation to approaching the NPS and offsetting. However, the key point is that a disregard of the baseline and the council endorse evidence appears to be a fundamental flaw as the starting point. The applicant's case is that, but for this proposal, Indigenous biodiversity on the site will not necessarily otherwise be protected and could be far more significantly degraded. It is clear, that concludes sort of the permitted baseline concept. The next sort of legal construct is how to characterise an offset effect under section 104D and section 104.1. So it's clear that under section 104D of the RMA, it's not permissible when considering whether the adverse effects of an activity will be more than minor to take into account separate positive effects of the activity or the extent to which those positive effects might overall serve to counterbalance the more than minor effects. The exercise is reserved for the subsequent determination under section 104.1. In order to pass the effects gateway, an applicant must show the adverse effects as mitigated and the 4 separate positive or offsetting measures are considered and not minor. A key distinction then, when assessing effects under 104D1A, is whether a particular aspect of a proposal described as an offset, being a consideration that diminishes or balances the effect of an opposite one, serves to mitigate or diminish an adverse effect, or whether it more properly is said to introduce a positive effect as a counterbalance. So, based on previous High Court authority, the position was that offsets were in that latter category. That was the Buller case from 2013 in High Court, where over to the court acknowledged that offsets are a separate positive effect and not a mitigation of an adverse effect. However, recent authority from that Supreme Court East West Link case, the court confirmed, the majority judgment confirmed that in the context of determining whether an activity was contrary to a policy that sought to avoid certain adverse effects, offsets can in fact serve to avoid or mitigate such effects. The extent to which they do so, in other words, whether they serve to avoid, mitigate an adverse effect or are really an introduction of a separate positive effect, is a question of fact and degree. The majority of the court found an activity that would otherwise have more than transitory effects may nonetheless not result in adverse effects if those adverse effects are offset in net terms. It then went on to say whether the impact of the offset must be in situ or can be deployed elsewhere will be very much context specific. It will be imagined, depending on the environmental element or value that must be protected and the nature of the adverse effect that is to be offset. These are matters of evidence and probably largely expert evidence to be carefully assessed by the fact finding. Based on this finding, the extent to which offsets could serve to avoid adverse effects will be fact dependent. In many cases, the offsets would more appropriately be deemed a positive effect rather than avoiding an adverse effect. But what is clear, however, is the court's rejection of the suggestion that as a matter of law, offsets cannot function per se to avoid adverse effects. So the court in East West Link was specifically dealing with issues of offsets in the context of complying with objectives and policies that seek to avoid adverse effects. It was not asked whether offsets could serve to avoid adverse effects in the context of an assessment under that first gateway test. However, I submit that in principle there's no reason why the logic applied by the Supreme Court would not extend to an assessment under the gateway. Both are dealing with the issue of adverse effects. The policy overlay, which the court addressed, does not change that fundamental principle. Now, we're not aware of any cases subsequent to that East West Link Supreme Court decision that have addressed the issue. 2 cases that only come out subsequently referring to it, and neither of which were in offsetting context. Furthermore, there's also a bit of movement and an appeal on another forest and bird case on the West Coast last year, which is currently with High Court. And that environment court did approach the issue of offsetting as a basis of as if they are positive effects, as opposed to mitigation or avoidance. But it yet to be seen what comes out in the High Court. So stepping back from all that quite technical assessment as to whether an offset is a positive measure or an avoidance measure, which we say is sort of fact dependent, and I'll take you through the analysis of the same shortly. But in the context of this case, the issue is whether the relevant environmental offsets, being a substantial ecological program on and around the site proposed by the applicant, serve to sufficiently reduce the level of adverse effects on ecological values, or whether they introduce separate positive ecological effects. We note there is commonly a matter of distinction between parties as to that scale of when such measures turn from mitigation to offsetting or into compensation. In our submission, we're in the situation of an overall discretionary or non-complying activity consent. Less turns on how those measured and marshalled under the 104D and 104.1 assessments. And that's particularly given the case and a clear approach in the FSIB to assess offsetting policies under the effects management hierarchy for non-SMA mapped areas.
So I'm just struggling to understand the last one. Take me through that. So in our submission, where there's an overall discretionary or non-complying activity consent, which we've got here, what else would there? Don't be the only other one could be control or anyway.
Yeah, I think that's right.
Yeah.
What I've just talked through is how to characterise and offset in the context of those gateway policies.
Yeah.
And the point is that even if you were to find that in this case, because of the fact and the nature of the offsetting, that it were a positive effect and therefore that the 104D effects tests were not passed, we still say that the policy test of the gateway is passed, and you get to the 104.1 assessment after that. You consider offsetting in that realm.
Right. Okay. And just before you move on to the next section, can I ask what are you relying? To what degree are you relying on that aspect of positive versus avoidance? How important is it to your case? Because it seems that the cases you've quoted they're not quite there in terms of the exact circumstances. But is that an important part of your legal position here?
Yeah, it is an important part in terms of assessing the offsetting regime that is proposed by the applicant. And the degree to which that is like for like, I guess, for a common term, in terms of the adverse effects at the proposal site.
Right. So yes, okay. So you're urging us to consider it not just as a positive effect, but a way of avoiding an adverse effect.
Correct.
Is that right? Yeah. Okay. All right.
I could add to that as well. And in the fact that's
Yeah.
there's still a submission in the round. If you do find it's a positive effect, it would effectively outweigh the adverse effect when you look at the net gain.
Number 104.
And
Okay. Understood. Thank you for that.
okay, so the next section, I think this is our last sort of legal construct, and it's just about how to approach private covenants and the relevance of that in this context. So the evidence of Ms. Williams for the Department of Conservation claims that the private covenant between the minister and the landowner is a relevant consideration to the application. That's on the basis that ODP identifies the 10-year review process as an alternative statutory treatment for particularly significant information. The assessment of the references in the ODP to the 10-year review process with respect to misplaced. Those references do not flow through to any rule triggers for freehold land, nor the private covenant, and do not provide any meaningful protection of ecological or biodiversity values. The Commission is bound to follow the ODP and the higher order policy in this direction, not place weight or reliance on a private covenant. The covenant bears no relevance to the decision making under the roles of Section 104B and 104 of the Act. The position expressed by DOC's planner is in contradiction to established case law and is not supported by very general references made in the ODP to 10-year review.
Is it in other matter under 104.1C? I think that's what Ms. Williams is for Livingston?
Well, you know, I haven't found clear authority for that proposition. To the
okay.
contrary, I've cited at my paragraph 57, 58, for authority to the effect that,
Sorry, I preempted you there, sorry. Yep. Yeah.
that, you know, that those private property rights are not issued properly within the domain of Environment Board of Commissioner decisions. They are by nature sort of a private contractual agreement, if you will. And Mr. Grissom and I would often deal with sort of disputes around the interpretation of such in the High Court. And
Okay.
you know, it's often great,
Mm.
is what I'm saying. So to wade into that would be upfraught in a planning context.
Yeah.
So at my 58 here, I say that the, you know, for obvious reason for provisions of law concerning private property rights, for instance, here regarding the application and interpretation of the private covenant are not generally within the province of the consent authority. And on the basis of the authority of cited above, will suggest that you have no regard to the instrument in the decision making. Moreover, I think the position of Dockland Covenant is slightly misplaced in that it appears to rely on the proposition that the consenting proposal is to remove the conservation covenant and replace it with a private covenant. That's not correct. Rather, the applicant has volunteered the imposition of a private covenant to address the effects of the proposal on a long-term basis and volunteered an advisory note, which I understand is consistent with other recently approved CODC consents, giving notice, I guess, of that private covenant.
Yeah, I had a question for Doc about that as well. I didn't see anything definitive in the application where it's to be removed, but
No,
we'll come back.
that's not
No,
to be achieved through this process.
no, okay,
Yeah, so
thank you. Yeah.
the question of whether the objectives and conditions of the covenant are met or not, and in fact, what those are, what those mean, and what the wording means, is a matter of interpretation between parties to the covenant. It appears that Doc has based its approach to the proposal on the intentions of the covenant, rather than a focus on effects as guided by the ODP and the relevant higher order policy instruments in the Act. Even if the covenant were a relevant matter, and say that it's not, I set out there a number of issues as to its drafting. Now, I don't know if the commissioners have had a look through the drafting of the private covenant. It's very small writing, quite hard to read.
Yeah.
But, you know, stepping back overall, it doesn't actually provide a high degree of prohibitive protection. It's expressed in quite high level vague terms in terms of objectives for conservation outcomes. But when you get down to the nub of what could actually be precluded or restricted by the covenant, it's in my submission, it's not getting back on something that particular. So at 61 there, I suggested that overall declining biodiversity values under the covenant area had not been successfully arrested by that instrument. The applicant's proposal will, however, ensure meaningful, realistic and enforceable outcomes on the site that would not otherwise eventuate. At paragraphs 63 to 65, we also just observed there a general theme underlying the Dock case, which is that the witnesses called are all employees of Dock, and therefore there is an element of less independence in terms of proffering expert opinion evidence. Moreover, the approach taken by some of the witnesses and the language used demonstrates an approach based on that representing a position of their organisation rather than an independent assessment of the proposal. And I also come back to that point at 65, which you'll probably get sick of by now, but it's assessing that the site is currently unprotected in an vulnerable state, rather than a starting proposition that it is fundamentally protected as it stands now.
Yeah, so just before you move off the private covenant, does it set up another consenting regime through Department of Conservation? I mean, is it similar to the sort of mining on conservation land arguments? I mean, if consent is granted here, does the applicant still have a problem getting through Department of Conservation's own interpretation of its covenant or how they administer it?
So there are two clearer kind of restrictive elements that would require an approval process. One is the clearance of woody vegetation within secondly described land within the schedule.
Yeah.
And so the expression of the covenant is that woody vegetation can be cleared, but must first be approved by the minister and shall not be unreasonably curtailed when it's visit.
Right.
And then so that would require an approval process. And then the second part would be as to earthworks and modification and I think it's near is the wording of heritage sites.
Okay.
And again, I think that must not be unreasonably upheld. So I don't think those two elements in the context of the proposal would be said to defeat
Right.
consent.
Okay, that's the only reason I asked that question. That it's more a matter between the applicant and the consent holder potentially and Department of Conservation, but it's useful for the panel to know whether something could frustrate any consent we might try.
Absolutely.
Yeah,
Yeah.
okay,
That's right.
all right.
Very deep dark, so to speak.
Yeah. Okay, thanks for that. I'll let you move on to the next part.
So our next section gets a little bit more into assessing the contrasting evidence across the different domains of effects. So we've set these up in terms of landscape effects and then we'll move into biodiversity and some of the more minor players. In terms of landscape character and visual effects, the application is supported by landscape assessment carried out by Mr. Baxter. Mr. Baxter has also prepared evidence and will address you on a summary statement as well later today. He concludes that the majority of the development is within the development area identified in the ODP. Controls will be implemented to minimise the adverse visual effects of the development. The proposal will constitute a low level of change in landscape character, most of which will be anticipated by that controlled activity regime in the development zone. The values for owner will be predicted and there will be a low level of adverse effect on landscape character and visual interesting values. Now, I'll pause there, just reflecting on your first question, which was about understanding a bit more about the origins of that development zone and its boundaries of the ground. I think Mr. Baxter will be able to take you through that because he was involved in the initial mapping process.
Yes.
So, got an expert on the job.
That might be useful to know.
Through that.
Thank you.
So Mr. Vincent and the council agrees that adverse visual and temporal character effects will be no more than minor. Ms. Lucas, however, the landscape architect engaged by Ms. Kenderdine, does not agree with Mr. Baxter's opinion. She considers the proposal will result in at least moderate adverse effects and will involve inappropriate subdivision use and development in both the O&L and Rocky Point development area. We note that Ms. Lucas, whilst also purporting to give evidence in accordance with the Code of Conduct, makes no reference to or disclosure of the fact she is the sister of Ms. Lillian Lucas and Ms. Helen Fletcher, who are both submitters in opposition to the proposal, and is the part owner of land at Terrace-Common Road opposite the site. That's despite the requirement in clause 9.2 of the Code of Conduct for experts to declare any interest they may have in the outcome of the proceeding. And furthermore, her evidence appears to strain to matters beyond her expertise. And Mr. Baxter can address that last point as well. In any event, we submit that Mr. Baxter more appropriately and comprehensively addresses the effects of the proposal on the character of the landscape in the context of not only the physical environment, but also what is anticipated under the development zone. Ms. Lucas, whilst acknowledging the development zone, appears to treat any visibility of buildings as an adverse landscape effect, seemingly on the basis that such visibility of buildings triggers a discretionary activity resource consent. This misconstrues the nature of a discretionary activity status, which is not, in the absence of supporting objectives and policies, to necessarily avoid activities, but rather to allow them to be assessed merits. On that point, Mr. Brown will also take you through the relevant activities and policies that will guide that discretionary assessment as to visibility. So that might help some understanding of, whether those are, if you like, hard and fast sort of avoidance of visibility policies or not. In my estimation, they're not. So that will probably help to understand the point of that submission as well. So at 742 there, the evidence also overstates the level of visual effect from distant locations and proceeds on the assumption that the proposed mitigation planting will serve to reduce any adverse visual and mental effects to a low level. She suggests that planting is impractical and unsustainable. However, that doesn't appear to be based on any reasonable evidence or proposition to support that assumption. In response to the section 42A as to landscape and visual effects, so that's in the 42A addendum, Mr. Vincent concludes that there are no more than minor visual effects from the proposal, including in relation to those lots outside the development zone and the ODP. Minor queries were raised in relation to conditions as to height level measurements, lighting, future variations, and design controls, all of which are addressed in the evidence of Mr. Baxter and Mr. Brown. Mr. Vincent finally raises the issue of effects on open rural character of the area as a result of clustering lots 27 to 30. In response, the applicant filed further supplementary evidence from Mr. Baxter, providing a revised landscaping approach for these lots, with the intention to ensure that effects on open rural character were appropriately mitigated. So that was that. It was a one-pager brief, but it had a bit more sort of clarity in terms of the intended mitigation effects for those lower down platforms adjacent to the road.
Okay.
In terms of heritage and archaeology effects, Mr. Brown assesses effects on heritage and archaeology as minor on the basis of Dr. Jennings' assessment and recommended conditions to protect two effective features found within the site. Key issues raised in Doc's evidence to counter this decision relate to the appropriateness and rigor of assessment and the identification of heritage and archaeological sites within the wide site, and a lack of consideration of avoidance as a management measure as an RMA best option, rather than what is required just under the Heritage Conservation Village Development Act. Dr. Jennings remains of the position that features within the site are not found to be regionally significant and rare. They have low information potential, are in poor condition, and have low amenity value, even when considered as part of one complex of sites. He considers the site has been thoroughly investigated and correctly identified, and the management responses are appropriate in context. Avoidance of the feature entirely must consider more than just the fabric of the site. If the values of the site are dependent on its setting and a landscape, or within the context of associated sites, then the effects of a redesign would have on those values must be considered. The applicant has explored potential redesigns as a way to avoid a particular feature 771. However, considered this would be difficult to achieve for landscaping and construction purposes. Dr. Jennings also concludes that these sites would be appropriate for detailed reporting instead to mitigate any loss of their relatively low heritage site value. Dr. Schmidt, the doc, obviously disagrees and considers that those sites are part of this network or a site complex, they should be retained. In the first instance, he clearly has a lower bar for condition than Dr. Jennings and considers the reservoirs are in good condition. The archaeological value is the site's potential to provide evidence relating to the history of New Zealand, and I submit that the Commission will likely observe this in their own site visit and agree that 771 in particular was of low value. So, yeah, I guess I'll let you make that observation for yourself, but it was certainly our observation on site that it was quite difficult to discern from a lay point of view, those features on the ground. It also is submitted that the approach from Dr. Schmidt for DOC is overly orthodox and that, the evidence proposed profit is not purely independent expert evidence given his DOC employment. It lacks real world analysis of the site containing significant development area and the expectation of the same through administration of the district plan. And the sites identified are arguably not as rare as asserted. There are two of those sort of reservoir dam features on the site alone, that's 771, 773. And there are others in the wider catchment area that everyone is aware of. And Dr. Schmidt himself highlights the representation of these remnant features across Otago goldfields. In the addendum report, Mr. Vincent concludes on the one hand that on their own heritage and archaeological effects should not be favourable to the application if other matters can be resolved. But on the other hand, he remains concerned as to adopt positions on such effects in light of the conservation covenant. He refers to that as having effect in its current form. I suggest that those two positions are somewhat contradictory and confusing. For the reasons I've already set out, the private covenant between DOC and the landowner is not relevant to interpret or apply in the Commission's decision under Section 104D or 104 of the RMA. The Commission must make its determinations on heritage and archaeological effects as guided by expert evidence and applying the same to the ODP. On this basis, it is suggested that Mr. Vincent's conclusions as to heritage and archaeological effects can be narrowed with the removal of the reliance on the covenant as a relevant matter and are overall not relevant minor.
Just remind me, I should know the answer to this, but the listings G 41771, are they heritage listings or are they in the district plan? I just can't recall. Are these sites listed in the district plan?
They're not in the district plan, those are listed where excellent.
Thank you. No, thank you. I should have remembered that. Thank you very much. Yeah.
Okay. And Dr. Jennings will obviously also be here, presenting some suffering.
Yeah. No,
further questions on that.
thank you.
So in terms of the ecology and biodiversity effects, this is really a key issue as to really a question about, characterising those lots of effects. Now, given the NPSIB is relatively recent, there's limited high court authority on its application and offsetting approach. So we've done our best here to collect up the highest and most relevant leading authorities on it, but it is, I caution you that it is relatively new. Overall, the NPS has the goal of maintaining Indigenous biodiversity nationally so that there is no overall loss. This is achieved through a number of measures identified under the core objective to including protection and restoration of biodiversity while providing for the social, economic and cultural wellbeing of people and communities. Now, Ms. Williams in her evidence omits where she talks about that objective to an NPS matter to the Roman 4, which is about that provision for social, economic and cultural wellbeing. And that, in my submission, brings an overall balanced approach to that key objective of the NPS. Now, that's particularly relevant to the site in this instance, which contains, and I keep going back to this, the expected development zone, as well as the relevant baseline, which would allow economic activities to proceed with significant adverse effects on Indigenous vegetation otherwise unhindered. Ms. Williams' one-sided approach to the NPS appears to have coloured or influenced some of her evidence and conclusions. So now we'll talk about scheduling SNAs under the plan versus under the NPS. The experts are in agreement that the site would meet the significance criteria of the relevant statutory documents, being the NPS and the operative and proposed Otago original policy statements in terms of future SNA identification, and is considered to contain very high ecological values. As it stands today, however, the site is not mapped or scheduled as an SNA for the purposes of the ODP. It therefore triggers no rules and is the same. The Commission will be aware of the recent deferrals of the NPSIB direction and timeframes as to future SNA input for local authorities. That's the recent Resource Management, Freshwater and Other Amendments Act that's come out in the last month or so. And therefore the requirements of clause 3.10 to 3.11 of the NPSIB do not apply in this case. Those are the clauses about mapped SNAs in the district plan. Rather, the effects management hierarchy applies to adverse effects of the proposal on other Indigenous biodiversity values outside of an SNA, as per clause 316 of the NPS. Ms. Williams goes on to suggest that the council, however, could undertake a plan change to bring forward mapping of the site as an SNA into the ODP, despite that recent legislative change. I accept that that is a possibility. It's hypothetical. The council could initiate that plan change. But in our submission, that possibility is entirely irrelevant to this decision. To the contrary, without this proposal obtaining consent, the site will remain less protected overall in terms of biodiversity given that committee baseline. So the gist of that is all of the experts agree and appear to be in alignment that using the new criteria under the NPSIB as to what would be identified as an SNA would qualify as such. It doesn't therefore follow that it gets treated as quasi SNA and district plan rules at the moment. Those provisions of the NPS don't kick in, if you will, until a further plan change is notified and implemented to have that back area defined as an SNA.
Yeah, thanks for explaining that. I'll be interested to hear if there's a counter submission on that, but in any event, if the agreement is that the values are significant enough to qualify for an SNA, section 6C of the Act will still apply, won't it? So I'm trying to understand how that changes things. Whether it's mapped or not, how important is that in terms of section 6C?
And my assumption is it's important and it's relevant to the permitted baseline concept because section 6 of the Act in and of itself doesn't create a rule for it. It doesn't include the implementation of those permitted activities like farming and horticulture or viticulture, that I've talked about that could occur on the site. It doesn't create a trigger.
So the hierarchy for offsetting and so forth. Okay. So that the provisions of the Amendment Act don't apply. Essentially, is what you're saying. Is that right? Because it hasn't been mapped. The reality is that the council hasn't done that, and so is it your legal position we don't have regard to that Amendment Act because the mapping hasn't taken place?
So you don't have regard to the site as if it were an SNA defined by the plan. which
Okay.
trigger-
So we consider as an unmapped area,
Yeah.
which and then so the avoid threshold is not part of that, or I guess that'll come up in evidence, but
Is the avoid threshold coming through?
if it's unmapped compared to mapped, there must be a higher threshold for mapped, and that would be the avoid threshold.
It's those
Yep.
3.10 to 3.11 costs increase.
Yeah.
Mapped SNAs.
Okay, so they won't apply to unmapped. Okay, even so 6C is a broader sort of view of it. Is that what you're saying? I'm still trying to understand that how 6C relates to.
So obviously sets the legislative direction to protect individuals by these values. Can't recall if it's from an appropriate development.
And we
It's not that, but
no
under the NPSIB, it
Yeah.
separates policy direction
Yes.
for mapped SNAs
versus unmapped.
versus unmapped.
Yes, that's right.
It sets out a new criteria
Yeah.
for assessing what would be an SNA to make that nationally consistent.
Okay.
The recently passed RMA Amendment Act
Yeah.
has deferred the mandatory mapping of that to councils. So
That's-
it's just can go.
Yeah.
Okay. So all of that means that as of today, site is not treated as an SNA under the ODP triggering SNA rules.
That's right. So it's the rule link, but under 6C, if it's agreed by the experts that the values are significantly high,
So
avoid may still be irrelevant. It may still be relevant for us to consider avoidance just under 6C, isn't it? Yeah.
that's right.
Yeah.
And that flows through to that clause 316 of the NPS.
Right.
That gives the direction for the effects management hierarchy on significant Indigenous vegetation, biodiversity rather, outside of land.
Yeah. Okay. All right.
Yeah.
Sorry to labour that, but it's quite important. Yeah. It's quite important, and we'll hear more on that, I'm sure. Thank you. All right. No, look, thank you very much for that. And we're up to the next offsetting.
So in terms of the proposed offsetting and overall adverse effects on biodiversity values, as I've set out here, first of all, is the assessment of the first gateway test under 104D and whether the proposed economic offsets serve to avoid adverse environmental effects or whether it constitutes a separate positive effects. And in that case of the latter, if it is the latter, the applicant would accept that the proposal does not pass that first gateway adverse effects assessment, although the offsetting would then be irrelevant considering consideration under 104(1). So the determination of that issue involves an assessment of the particular effect in question and what is sought to be protected. Mr. Harding for the council and Mr. Ewens for DOC take a narrow view in my submission as to the nature of the effect. They say because the proposed revegetation is not sufficiently like with the vegetation being removed, it cannot serve to reduce adverse effects associated with removal. We say that's not a correct approach for several reasons. First, it is artificial to apply such a granular level of assessment of any particular effect. To do so would invariably mean the level of effect would be more than minor. Any change to an environment, if the change was assessed at such a finite level, would be seen as adversely affecting the environment because it is removing or changing what existed before. It's well understood that assessing effects on an environment must therefore be at the appropriate scale. When the appropriate scale is applied, the question to ask is not whether particular species of vegetation or areas of vegetation might be lost, but whether the overall effect of the proposed activity on ecological and biodiversity values will be a positive or negative. The clear ecological evidence of such effects will be positive. This requirement to apply the proper scale is supported by the NPSIB. Its objective to ensure there is no overall reduction in Indigenous biodiversity, as well as the principles of offsetting in Appendix 3 of the NPSIB, which are more extensively addressed in evidence of Mr. Beale and Dr. Wells. Additionally, the at risk of repeating the point, OU itself does not protect vegetation or restricts removal at a particular species level or otherwise. At the removal of specific species and specific locations constituted an adverse effect could not be offset by planting and maintenance elsewhere, then the plan would not permit the removal of such species on the site. As Mr. Brown correctly puts, the position of the council and DOC incorrectly assumes the status quo protects the Indigenous vegetation that exists on the site. We say it does not. In terms of the likely success and the effectiveness of offsetting, the Environment Court has acknowledged the inherent uncertainties in offsetting in recent case law, which analyse the offsetting principles in the NPSIB. Now that case, Te Rūnanga Ngāti Whātua, last year is the only case that we found which is actually specifically addressed the offsetting principles in the NPSIB. But we also noted it was before that East Queensland Supreme Court case. So on the point of assessing those offsetting principles, it said that the court must be satisfied that net gain outcome will be achieved and is measurable over a reasonable time frame. This inevitably requires that risks as to outcome are addressed by contingency planning to assure the outcome. We understand that any mitigation project, including riparian or terrestrial planting, fauna, translocation, habitat restoration, will take time for the benefits to be realised, and that is taken into account in the modelling. But also understand that the modelling itself is used to estimate the time that will be needed for a positive outcome to be observed. So a key issue from the differences between the expert opinions is the extent of certainty around the delivery and effectiveness of the applicant's proposed offsetting package, including the risk of non or partial compliance. For offsetting to be acceptable in light of the scale of adverse effects predicted by the NPSIB expectations of both adherence to an effects hierarchy and then a net gain to be achieved by offsetting, there must be a high level of confidence in the quantified values needing to be offset. Without this, NPSIB cannot be said to be being appropriately implemented. We submit that there can be a high degree of confidence in implementation of offsetting in this case, given the clarity and stringency posed in Mr. Brown's conditions of consent. Condition 10 effectively acts as a gatekeeper to implementation of the subdivision for tightening, subject to certification and sign-off as to completion of the prescribed offset package. A high degree of oversight and enforcement is available through the requirements of the EEMP's monitoring and annual reporting and long-term maintenance. As to the certainty of quantified values to be offset, this is addressed in the evidence from Mr. Beale and Dr. Wells in terms of the extensive investigations of the site and the evaluation that maintaining status quo of current vegetation types or species only should not be preserved as a museum piece where it is successional anyway and will become more complex over time, if current fish seeds and more complex and diverse seed sources were available. As is acknowledged, any offset model is just that, a predictive model as to effects which inherently have some residual degree of uncertainty. That's an accepted element of offsetting under the RMA and the NPSIB, and in this case, the evidence and the conditions of consent reduce that uncertainty to an acceptable level. In terms of assessment of differences in evidence as to offsetting and when it's appropriate to use, Mr. Harding and Mr. Ewens consider that offsetting is not appropriate in this case due to a lack of baseline data or information and inconsistency with principles of offsetting. Dr. Wells and Mr. Beale have prepared summary statements to talk you through each of those issues in more detail this afternoon, but in summary, the differing survey results as between Mr. Ewens and applicants' experts are not irreconcilable. Spring annuals are variable year to year and are also short-lived. The dock site was a strengthened underlying assumption in Dr. Wells' evidence that these species are likely to be abundant across the wider landscape, wherever there is suitable habitat. The fact that they are a wider seed source across the site is particularly relevant when considering the extensive area to be protected by the private covenant approach offered by the applicant. And that's not currently protected by the existing dock covenant or ODP container. The removal of spring annual habitat from the development area will not adversely affect the well-being of populations of those species at a local or national level. And that's the similar reasoning that's already set out in those events. Again, we'll talk to that this afternoon. Threatened spring annual and other herbs and grasses are only one small component of the ecosystem. It appears concerning that dock submission seems to be based on these species alone, and there is no acknowledgement of any other flora, fauna, and ecology of the area of the proposed effects management package set out by the applicant. Seems to show a lack of holistic ecological thinking that is integral to achieving a net positive overall outcome for Indigenous biodiversity. Doc is correct, however, that the applicants' experts had not assessed the offset sites for spring annuals specifically. However, again, Dr. Wells will address you on this afternoon, but those sites have since again been visited with a view to ascertaining that, and the experts remain of the opinion that any concern as to leakage effects would be negligible. The results of the dock site visit and the applicant surveys indicate that the spring annuals are abundant at the local level, both within the development footprint of the proposal and within the balance of the site to be protected, as well as at an ecological district level where carnival shrubland and cushion field occur together as a mosaic. The dock site visits results further confirm the very high score the experts have given to ecological values inherent in the development area, noting that the ECIA guidelines assign a very high value to the presence of nationally threatened species in the permanent proceedings. So in terms of the RPS, this is an interesting discussion because the operative RPS and the proposed RPS are in a state of flux. The proposed RPS is currently subject to extensive environment court that is on non-freshwater parts and high-fat fields on freshwater parts. We were both involved in those hearings and observed a number of discussions and submissions around all manner of provisions, including the approach to offsetting principles, which are set out in those in the appendices to the RPS. We note that the criteria in the RPS are also subject to extensive appeals. And as a result of such, we suggest that limited weight should be placed on them. I set out there at my paragraph 111 a screenshot of the Oceania Gold Appeal as an example of just to demonstrate how the criteria in the proposed RPS goes above and beyond, if you like, the NPSIB offsetting criteria. So the offsetting criteria in the NPS is set out in its Appendix 3, and the experts have systematically taken me through each of those criteria to determine how the offset package proposed is aligned with and consistent with that approach. there are additional and extra criteria in the PRPs, however, for example, relating to the loss from an ecological district of individuals of threatened taxa and such. Those are not criteria or words that appear in the NPSIB. So my submission here, because you've got the operative RPS and the proposed RPS both predating the NPS criteria, we must be guided by the higher national direction because the RPS flow from those, and also because they predate it. And furthermore, because they are subject to extensive appeals, including because of the issue of being going above and beyond the offsetting criteria and NPS. So that's why I say that the advocacy experts have been guided by the offsetting principles of the NPS. But Dr. Wells in particular has set out the tables and his evidence assessing each of those offset principles and can take you through those this afternoon as well.
Understand that. So both regional policy statement documents were pre-NPSIB. So if we place less weight on the proposed one, it wouldn't follow that we place more on the operative one, would it? Because they're both limited in what and how they deal with it.
That's right.
Is that right? Yeah.
Guided by the national direction.
Right. Okay.
Yeah.
Yeah.
I think it's a leading principles box again.
All right. Thanks.
So, Mr. Vincent, also this is the top of page 31 of my submissions. Mr. Vincent prefers the position of Mr. Harding's peer review on ecological effects and offsetting than the book and its two experts, and therefore remains concerned for the proposal would have more than minor effects on overall existing ecological values for the area. Again, I suggest, and you're probably going to sit with this point, but we suggest that that's a flawed proposition because it fails to take into account that relevant permitted baseline scenario to the site, which could result in significantly worse next ecological outcome. The starting point appears to be flawed in Mr. Harding's peer review, which does not account for this permitted comparison and assumes that NPS and a direction of avoidance that you've just been talking about in section 60 of the Act together provide an actual and real protection in terms of rules on the site. Secondly, the position is also predominantly based upon an assumption for Mr. Harding that the use of the EIA NZ method to assess ecological effects is not appropriate. Again, Mr. Beale and Dr. Wells assess those criteria as being acceptable, best practice, and the applicant has expended significant resources into comprehensive ecological baseline assessments. I was also having a look this morning, just quickly, at the NPSIB section 32 report, and I note that it does refer to reliance on the EIA NZ criteria as one of other reports which were sort of relied on in the assessment.
Yeah.
So,
how critical is that to our consideration? Because I think Mr. Beale has addressed it by saying, regardless, he agrees these are highly significant vegetation.
that's right.
Whichever way you come to it, that's his conclusion. So I'm just wondering how much time we need to spend on the EIA. Yeah. All right.
The disputed evidence is the high value.
Yes.
And equal approaches to, how you go about offsetting.
And just one more question on A, 1112A. Ms. Williams has basically, as I understand it, has said the permitted baseline should not be used. We should exercise our discretion not to use it, because to do so would be contrary to Part 2 of the Act, because clearly the site has values that haven't been recognised in the district plan. The district plan's quite dated. It hasn't been updated. And is that a valid legal argument? Is it a valid argument legally?
Yeah, so in my initial, the first part of my submission, I talk about the case law guiding where the discretion has been exercised to make a private baseline. The case I referred to does include where the outcome would be contrary to Part 2 of the Act. So as a concept, that is an available mechanism if you do apply that discretion. However, I've already touched on this, but I don't think that your observations and Ms. Williams' observations that the plan, predates the NPS, that it is some out of date means we can throw the baby out of the bathwater entirely. I think that what the applicant has done in light of that is assessed its district plan assessment with a really close eye on the NPSID and has assessed the NPSID really closely. And the conclusion is that the applicant's proposal will actually be to achieve the outcomes intended under that NPS and part 2 than in the current state,
Yep.
which is not protected.
Yep.
Um,
Yeah, you did cover that earlier, sorry.
and it's right to back to
Yeah.
the perverse outcomes of not applying the baseline. And I actually do think that, you know, there would be perverse outcomes in terms of achieving part 2 to not apply the baseline because it effectively is saying, well, you know, despite the extent there being no rule triggers which protect the site from Indigenous biodiversity clearance under a permitted or full cultural regime. We won't acknowledge that in a consenting context, which does really stringently and clearly seek to protect those values through an ongoing carbon emission.
Thank you.
So I think we probably done enough on section 42A assessment, and I'll take you to our 115. And overall, it is submitted that the evidence and assessments provided by Mr. Beale and Wells are more comprehensive, better informed by multiple site visits and analysis on the ground, and provide a more prescriptive assessment of proposed offsetting against the NPSID principles. Dr. Wells attaches to his evidence a table assessing the responses to Mr. Harding's views as to why offsetting is not considered appropriate. And I see out the key conclusions there as well. In particular, the core issues relate to NPS principles of irreplaceability and vulnerability, and his concept of offsetting being more closely aligned with progress towards an idealised or climax state of biodiversity, rather than ignoring vegetation that would have occurred or is expected to occur on the site. We say that it's closer aligned with the intention of offsetting in the NPS to ensure offsetting is of the same ecosystem type, rather than just a replacement of like species at an individual level. At 117, we therefore submit that Mr. Beale and Dr. Wells' evidence on the ecology and biodiversity effects is more considered, is based on real world of a limited baseline, and is closer aligned with the NPS and is to be preferred. Ms. Wardle has also tabled a letter in advance of the hearing. However, it appears to be somewhat framed as if it were expert evidence. We suggest some caution should be applied to that evidence which has not been prepared in accordance with code of conduct.
Yeah, we're not going to take that as expert evidence. I think Ms. Lyons clarified that with Ms. Wardle that it's not expert evidence. It's a tabled letter. Yeah.
Okay, we won't over the point,
No,
sir.
that's right. Yep.
Yeah, so
Okay.
we note some other issues that are expressed in that letter as well. But they really sort of align with common themes that were addressed in terms of the issues of the other competing expert evidence as well. So probably don't need to labour those points as well. So in terms of now turning to other adverse effects, the applicant has called the expert evidence in relation to servicing, traffic and transport and virus. The experts have addressed all outstanding matters in the section 42A addendum report and will address the commission on the same through their summary statements today. The applicant's case is that as such, there are no more than minor effects from those matters, and all issues raised in the 42A addendum and initial reports have been addressed. At 121, I make a conclusion here in terms of environmental effects overall, which I'm going to take you through. And at 1041, under my paragraph 122, we talk about this overall and round test of section 1041. So starting at A, we submit that the proposal will result in a number of positive effects, including the proposed formal protection of a significant majority of the site through ecological and vegetation management plans, consent notice conditions and covenant mechanisms to provide clear and enforceable protections that endure, landscape mitigation planting around building platforms and curtilage areas along with rabbit and goat control and stock exclusion, implementation of the Rocky Point Servicing Entity, which will ensure a high degree of regulation and oversight of the proposal, and therefore decrease the regulatory burden in council, and ensure delivery of positive effects over time. Recreation opportunities are improved through commitments to provide new public trails and car parking, and positive social and economic benefits through the creation of allotments, mostly within the identified development zone footprint. Taking you to page 35 now. We briefly touched on the district plan assessment. That is, as you know, the in order to pass through that second policy test of the gateway. And I've set out there some of the core policy directions relevant to significant Indigenous education. And consistent with the theme of my submissions, I suggest that this exemplifies an approach in the ODP signal towards protection of map DCAs that are scheduled, but it's not well placed to currently protect other areas of privately owned significant vegetation. So the site is highly vulnerable under the status quo, and we suggest that can be remedied through this proposal, but it wouldn't necessarily be the case under other credible community activities that could occur. In my submission, there are no avoidance type of bottom line policies in terms of ecology, heritage and landscape in the ODP. Mr. Brown's evidence addresses relevant objectives and policies of the ODP and concludes overall the proposal is consistent and achieves those. At page 36, I've set out the case law on precedent effects, which is not particularly at flux or controversial, if you like. Mr. Brown's position is that no precedent exists, in particular just for the balanced land, given tight ongoing registered controls in terms of landscape protection and restrictions on further development. At 131 there I say, in any event, the proposal does have its own exceptionally unique circumstances that mean it is unlikely to be replicated elsewhere in a precedent sense. Namely, it's an integrated proposal that comprehensively addresses landscape, ecological and other environmental effects through a stringent condition set. It is a unique property that is centred around a development zone and with a highly complex environment. The establishment of management entities, balancing controls and offsetting sites are all mapped to the site in the proposal. However, the Commission did disagree with that and considered that either the proposal or part of it would set a precedent. We submit that would be an appropriate precedent to set due to the extensive mitigation and positive effects proposed. In terms of the conclusions, overall we suggest that the proposal is exceptionally unique, and that takes into account the available permitted baseline and significantly worse Indigenous biodiversity outcomes that could arise under the same. I've continued that trend through the submissions. The underlying development rights that emanate from the development zone, which underpin spatial planning and design to provide relevance to the receiving environment. And the highly sophisticated design approach to this proposal as a whole, including through comprehensive conditions of consent to secure significantly positive enduring effects. Enduring benefits. The applicant has provided a design-led master plan response to ensure appropriate mitigation of all environmental effects, including importantly the protection of Indigenous biodiversity values. This is an outcome that is much more desirable than what could otherwise realistically occur on the site under a credible permitted or likely consented uses. Given that, we submit the proposal meets at least one, if not both, gateway tests, and is supported by a robust expert assessment that demonstrates the adverse effects of the proposal being minor, and upon consideration of the relevant members under section 104 is appropriate and overall significantly net positive compared with that status quo.
Thank you very much. I've got a couple more questions, but I'm just going to see if my panel members go on the legal aspects. Any questions on it? Oh, it's not.
No, I think.
Right. Okay. Got two more. I'll stop now. The two questions I had. First of all, the offsetting biodiversity offsettings to occur on adjoining land or not on the application site. So some is on there. There's four. I think there's four sites in this, and there's three other sites or something like that. In relation to the off-site offsetting, that's also on land owned by the applicant, isn't it? TKO. And as a legal principle, is it necessary to tie that down? And perhaps Mr. Garden can help with this too. But do the conditions adequately provide that that can take place on an adjoining site, and the landowner can't relinquish the right to use that land for such purpose? I know it's the same owner, but legally, is there any impediment to doing that?
Yeah, so we've tried to tighten the conditions up as much as possible to ensure that the outcome could not eventuate. So,
Okay.
and that can certainly be put through Mr. Garden and Mr. Brown in particular, but the intention is that those sites are secured by a web, if you like, of private covenant, which could be enforceable by the individual lot owners.
Yes.
So that's a pretty comprehensive program, which is often secured in a development like this, where you might have a number of individual lots and a residents association or a servicing entity above those as well. Which creates sort of a double layer of enforcement.
I think that's important, because if, for instance, the development is built and then the offsetting doesn't occur for whatever reason, it's very hard to take the houses away. You know, it's important that that is absolutely guaranteed.
Absolutely. Sorry.
Yeah.
That importance, I absolutely agree with that, is on the ENP in terms of its annual reporting requirements as well. So it's all well and good to do that done, but it actually requires, you know, an ongoing level of
Yes, that's right.
oversight as well. And so that's certainly been the intention through that ENP as well.
Right. Okay. And in terms of the only other question I had on legal aspects was the bundling principle means that we're dealing with non-complying activity. But as I understand it, there are several consents required, and there's only one aspect that triggers non-complying, and that's the size of sites are too small. And I was going to ask Mr. Baxter this, and it's possible that they're deliberately made small to minimise the footprint, and could it have been possible for the development to fully comply with lot sizes and take it down into a discretionary status, for instance? And I know it's an academic argument because we are concerned with a non-complying activity, but I was curious as to how the rules work, and it has a big bearing on the way this is assessed.
Yeah.
Okay. So.
Through the gateway test.
Well,
yeah, I see that at page 12, Mr. Brown's convinced he sets out that one non-complying rule.
Yeah.
So 475 Roman 3 for a subdivision that does not comply, 472 Roman 2. Lots created that do not meet the minimum allotment standards, bulk location and open space and lot size for further simplification.
Yeah, it's about 2,000 square metres or something, and these are a lot smaller. I think that's how I remember it, but I guess it's just a question to put to the other witnesses as well. Is it a deliberate action on the part of the applicant to make these lots small, to minimise the footprint and visual effects and so forth? And as a consequence of doing that, is that what triggers the non-complying activity? It's just of interest for me to know that.
Yeah, I'm actually not sure on the answers to.
All right, that's fine. That's all right. It'll come. All right. Look, thank you very much. That was that's quite a long time, but I think it was useful because when we get to questioning the witnesses, we've already covered a lot of matters, so we can potentially short circuit some of that questioning. So thank you very much, Ms. Hill, for taking us through that. We'll take an adjournment now just for a cup of tea and 15 minutes. So we'll come back at 10:55. And I've just been asked. All right, we'll reconvene the hearing, folks. Thank you for that. Right, back to you, Ms. Hill.
Okay, thank you, sir. So we'll commence with the applicants witnesses to be called now. So we'll start off with statement from Mr. O'Sullivan and Mr. Garden. That there's quite a lot of alignment between the two. So
Yes.
be sort of any questions could maybe be answered effectively.
Sure.
But I'll leave that in. So something.
Okay, so thank you, Mr. Sullivan. Yeah, Sullivan.
Okay, Commissioner, fellow councillors and supporting staff. Following is my own statement providing an overview about the proposal, setting out our vision and addressing specific matters relating to consent. Tom is going to give a wee bit of background there, and then Mr. Brown's going to pick up that in with more specific detail relating to property point, and then it looks like he's going to continue on the functioning of services. So yeah, we've two areas within Central Otago, one the finishing block in Waikiri Valley near Alexandra, the other on what's extensive block at Luggett. Our companies have undertaken a number of rural land developments in Central Otago for the past 8 years. Our development philosophy is fairly simple, as we apply heavy focus on what is highest and best use. Wherever there is a suitable sustainable productive use, we have sought to enable this. Typically, this is done by bringing irrigation to formerly dryland areas and subdividing into more manageable blocks. The rural lifestyle subdivisions we have carried out to date have typically been on land that have had limitations for agriculture, viticulture and horticulture due to excessive contour. In basic terms, we pick the eyes out of it for viticulture and horticulture, and the remaining productive land is considered for further subdivision as rural lifestyle blocks. As farmers ourselves, it is our preference to retain land for productive use where possible. The acquisition of Rocky Point. TKO Properties acquired the 70-hectare Rocky Point property along with the adjacent 130-hectare Bendigo Hill property in 2022. The two titles, along with a number of other development blocks, have been subdivided off by the periods of the original Bendigo station in the early 2000s and in anticipation of further development down to rural lifestyle blocks. The Rocky Point was centred around the RURA2 zone and Rocky Point development area contained the CODC district plan. The origin of Rocky Point development area. The 21-hectare CODC zoned area at Rocky Point was included in the early iterations of the district plan in the mid-1990s. It coincided with the tenure review process for Bendigo Station. Our understanding from discussions with members of the Perrion family and others, along with a review of the documentation available at the time, is that Rocky Point Development Zone was a product of the cooperation between the Perrion family, Land Court, the Commissioner of Crown Lands, Central Otago District Council, and DOC during the tenure review and district plan establishment period. It also coincided with the completion of the Clyde Dam and the filling of Lake Dunstan, with those stakeholders wanting to facilitate a variety of land uses around the lake. The Rocky Point Development Zone sought to enable a combination of dwellings, visitor accommodation and hospitality at the top of the lake, whilst ensuring the ongoing protection of the surrounding natural environment. It is those objectives our proposal now seeks out to deliver upon. Thank you, Mr. Gardner, continue.
Commissioners and others. My name is Shannon Garden. I'll continue on with this own statement we have and progress on with the description of the proposed services edge. So, setting out a development philosophy that we have created and been pursuing with respect to Rocky Point. We believe that Central Otago lags behind Queenstown and Wanaka in offering unique developments suitably and sympathetically situated within natural surrounds. The 8-hectare averaging subdivision rules in the CODC district plan and lack of flexibility for better alternatives make this type of rock development, both to Rocky Point, near impossible. Rocky Point is a unique exception where the plan-enabled development zone anticipates a more intensive spacing of dwellings within a smaller footprint at a suitable scale within natural surroundings. We believe Central Otago also needs to continue to focus on attracting tourist dollars. Again, we fall behind Wanaka and Queenstown on this score. There is a need to support our wine industry with complementary tourism and hospitality facilities. Specifically, we believe there is an unrealised opportunity for wine tourism and associated hospitality around Bendigo. We see potential for further activation of the Bendigo Loop Road State Highway 8 intersection. There may be opportunity arising in the future from the Paris Airport. There is also the potential for significant industry and associated demand for staff and supporting services arising out of the Santana Gold mining proposal. Our Rocky Point development will complement all of these things. Our proposal is specifically designed to protect and enhance the wonderful natural environment that surrounds Rocky Point. We have chosen the house sites for development that are most suitable to receive built form without dominating the landscape. Our design seeks to minimise earthworks and impacts from installation of infrastructure. We are avoiding those areas within the development zone where building would lead to an undesirable level of effects. We have carefully selected a number of sites that extend beyond the development zone, where effects of development can be managed to a suitable degree. We have worked extremely hard to come up with a scheme that will work and which is sensitive to our environment. We're extremely proud to be enabling development where approximately 90% of the land area is preserved and enhanced through formal conservation arrangements. We're pleased to also incorporate some public walking access and amenity, including facilitating public access to and celebrating our Central Otago gold mining heritage. Touching on existing farming use as an alternative to our proposed development. Although the land has lain fallow for several years in anticipation of this development, the current land use remains pastoral farming. Rocky Point was, until this project began to take shape, part of the Bendigo Station farming system. We understand that it served as a holding paddock for large mobs of sheep coming off the hill waiting to go through the yards at the homestead below for gleaning or shearing or at other times of the year. At those times, the block was subject to significant stock pressure in the form of vegetation browse and the effects of sheep camping on dry open knolls. And this has also led to a proliferation of weeds via sheep droppings and stock droppings across the site. At various times, the area has been decimated by rabbits. Feral goats from the Dunstan Ranges pose a challenge even today. In its current use, the block can be top dressed and oversown, promoting conversion to more exotic grassland. Certain areas can be cultivated. Looking at more intensive uses, portions of the block can be cleared and converted to viticulture, as has been done to the north and south of us. If our consent application is not granted, it will be necessary to pursue some form of intensified viticulture or horticulture in order to generate some return from our investment. In summary, we consider our proposed advances for purposes and zoning anticipating the district plan. It has a clear positive effect on the natural environment when compared against viable farming alternatives. It will protect and enhance 90% of the total land area and the natural vegetative state. It delivers cultural and social benefits through opportunities for tourism and hospitality. It has the potential to complement the surrounding farming industry. In conclusion, we're proud to be enabling this development and look forward to your supporting our application by granting consent. Thank you.
Thank you. I'll just see if we have any questions on that first statement. More questions? Yeah, just from a very brief site visit I did yesterday, we haven't done a proper one yet, but I noticed the vineyard next door sort of seems to have terraces up higher up onto the hill, doesn't it? It's almost like terrace development. Is this site suitable for? Has it got similar landforms that would allow for viticulture? Do you think?
So right through the fence on the north side is plantings of grapes and yes, so that could extend through to certain areas of the north side.
All right. I've got no other questions at this part anyway. So yeah, thank you very much for that part of it. Thank you.
Thank you.
Thanks, Rick.
The next witness to the applicant will be called is Mr. Cowan. Oh, sorry.
Yeah.
Yeah, we'll start with the next.
Yep. Mr. Garden. Yep. Okay.
Very good, thank you. So summarising the evidence that I have provided relating to primarily to Rocky Point services and the ongoing land management.
Sorry, just 1 second. We'll just get the summary handed out. Thank you. Very good. Cheers. Thank you. Carry on. We're doing it this way to make things easier, just summaries before each witness, otherwise we'll the mountain of papers that we get mixed up. It's, all right, just proceed when you're ready. Thank you.
Thank you. My evidence addresses the arrangements that will be put in place to ensure appropriate ongoing management of shared services and of the commonly owned rock area at Rock Point. The purpose of outlining these arrangements in this forum is to provide certainty that the land management outcomes that TKO Developments and TKO is proposing will be delivered through formal and sustainable means. The services company, yet to be incorporated and assumed to be named Rock Point Services Limited, RPSL, will be incorporated by the owner developer as part of the development process. It will have a tailored constitution. Ownership will be transferred from the developer to incoming owners as lots are titled and on sold. Ownership will be linked to land. A services agreement will be put in place between RPSL and each lot owner. That services agreement will be registered as a covenant on each lot title. RPSL will manage shared domestic water infrastructure, shared fire risk management infrastructure, common wastewater infrastructure, common private access ways, and the 47-hectare common area. RPSL will be a party to the design covenants. It will inherit from the developer the ongoing obligations set out in the ecological and monitoring plan and fire risk management plans. It will also hold the aggregated water right from the Chinaman Serious Water Scheme on behalf of lot owners. The structure and set of arrangements is adapted from a template which we and others have used successfully across a range of rural lifestyle developments in Central Otago and beyond. Addressing several matters raised by submitters and in the Section 42A report. Firstly, public access and walking tracks. Both Mr. Vincent and submitters raised the underlying objective of enabling public access in the landscape protection area of the REU RA2 zone, as further described in the concept plan at Schedule 19.16 of the district plan. That public access objective is described in Schedule 19.16, relates primarily to accessing the what is named in that schedule as the Manuku Reserve, more commonly referenced these days as the Dock Scenic Reserve, to the east or behind Rocky Point. We note that the current Rocky Point title does not now neighbour the Scenic Reserve, the Dock Scenic Reserve. Public access to the reserve is enabled and located elsewhere in the REU RA2 zone and the neighbouring property to the south. Notwithstanding this, the proposed scheme will bring public or vested road into the Rocky Point development. So we believe there is a public benefit in making walking tracks available for public use and recreation. This tracking will be on private land within the 47-hectare commonly owned area of the Rocky Point. Mr. Vincent, in his supplementary report, sought additional clarification on how that public access will be managed. As RPSL will manage the common area for lot owners, we believe it's appropriate that RPSL also assume responsibility for the designated public access tracks. Given RPSL's limited resources, it will be necessary that public access be limited in extent, that the tracks themselves are built and maintained to a simple and basic standard, and that RPSL does not take on unsustainable cost or risk. Accordingly, we seek that consent conditions are carefully considered so as not to impose an unsustainable scale of public walking tracks, nor create an unsustainable burden on RPSL. And so there is a level of tracking indicated in our scheme plans. There is the possibility of further involvement and support by both council and DOC in managing these tracks. So this is not a necessity and can be considered further at a later time. Turning to management of the common area. Mr. Vincent, in his Section 42A report addendum, proposed the idea that there be a QE2 covenant or similar imposed on the common area. While we accept that this is possible, we propose that this is not essential to the conservation and protection of that natural asset. We propose the option of overlaying further administrative structures such as QE2 covenants be a matter for the owners and possibly with some input from other stakeholders post-development. Protection of the natural area will be formalised through the land management regime described above. The common area will be owned as undivided shares in common by all 30 lot owners. No disposal or alienation or sale of their common area is possible without the support of every one of those owners in common. The constitution of RPSL, and this is referencing the template that we've used and we've found to work very well. Constitution of RPSL requires that the company does not operate for profit. So uses such as leasing the common area for a return would be prohibited. Registered building control and land management covenants, which also incorporate the ecological enhancement and monitoring plan, impose formal controls on the use of the common area. Each lot owner, along with RPSL, is a party to and beneficiary of those covenanted protections. Any variation to the covenants will require the support of all 30 lot owners. Obviously, being a variation to 30 titles, this will also involve scrutiny and guidance from 30 solicitors representing each lot owner. We would suggest that people will buy property at Rocky Point and live there for the very reason that they find value in the surrounding natural area. While owners will have different views and may propose different forms of use, it is a very high bar to assume that all lot owners would simultaneously agree to compromise the amenity value, being that open space that underpins their property values. Mr. Vincent does not offer thoughts on how the proposed land management structure is deficient, nor how a QE2 overlay will improve that situation. Accordingly, I propose that this not be mandated as a condition of consent. Turning briefly to the overlay of the DOC covenant, we see an opportunity at Rocky Point for the DOC to partner with landowners, taking some supporting role in the formal and conservation-focused arrangements that will be put in place. The land management structure that will be delivered by RPSL at Rocky Point will ensure focused and contemporary conservation management across approximately 56 hectares or 87% of the Rocky Point site. This conservation effort will be funded by levies from owners themselves. There will be no cost to the public. It will be actively managed under formal legal structures by owners with an aligned interest in protecting natural amenity. This may lessen the burden on DOC to manage these outcomes itself. It will also provide for a greater level of active protection than the DOC covenant in its current form is achieving. So in conclusion, I consider that the RPSL land management structures will be both appropriate and effective in delivering the stated outcomes for Rocky Point.
Thank you for that. I'll just check with my commissioners. Questions?
I purchased a block of dirt in this development. I'm obliged to become a shareholder in RPSL. That's part of the sale and purchase agreement.
Exactly, condition of sale purchase.
What happens if I'm one of those anti-people who don't want to do those sort of things once I've bought it?
So there is the regime set up in the Constitution anticipates the rotational participation of owners.
Yeah.
But as is human nature, some people will gravitate toward that and others won't. But at this scale, what we've found is that there is a high degree of participation and interest from owners.
I'm just referencing sort of similar sort of proposals around Queensbury and places where there have been some issues, especially around water. Well, they resolved internally, or is there some sort of mechanism for them to be dealt with by an external body?
So what we have found is it becomes quickly desirable for that, well, essentially service management entity to contract appropriate expertise. So unless there are specific qualified expert people within the owner group, you would want to outsource water infrastructure management and some of their services. I mean, for example, you can hire in qualified and experienced pest management people. You're not going to have owners doing it themselves. So it is appropriate that governance group outsource, raise levies from owners and outsource to qualified, skilled people.
A question?
Okay, I've got a couple of questions of your evidence in chief, so I'll
Yes.
just refer to the paragraph numbers in there. Thank you. Yes, I was just going to ask a similar question to what my colleague asked about how a new owner is locked into this agreement. And I think what I'd like to be taking with Mr. Brown is when we get to conditions, just to show us how the condition works, but you needn't worry about that right now. But you've told us that will happen. That's going to be a requirement. So anyone buying one of these lots has to be part of that agreement. That's the bottom line. Yeah. Okay. All right. Can you tell us about any other? You've been involved in these sorts of structures and other consent developments. How have they worked in your experience? I mean, have they worked well? Have there been issues? Or?
The underlying structure works well. And so what is important is to be very clear on how the structure works as people take possession of their properties. So and then to ensure right from the outset that there is active owner participation, that they have a sense of responsibility in what they're doing. So I suppose it's a way of saying, yes, we have a high degree of confidence in the structure. Its effectiveness to some degree depends on that handshake process between the developer and the incoming owners, and making sure that they get involved, feel a sense of ownership, understand what they're doing.
But in your experience, it has been effective. That's what I'm after. Yeah. Okay. No, that's worth knowing. Thank you. And then in your paragraph 11, there's five key facets which will be managed by RPSL, and you've listed them there: water infrastructure and so on. What about obtaining regional consents, for discharges and things that apparently still have to be obtained down the track? Does your RPSL organise discharge consents and the like for the infrastructure?
So that will turn on the obligations on a developer prior to Section 34C
Right.
and post. So,
Okay.
so RPSL will act as the developer prior to, so the
Right.
developer can incorporate that entity.
Yes.
And should RPSL be required to hold consents, that would be set up, and those consents will be within RPSL at the time of the titling of the.
So the idea is to get that all sorted out so individuals don't have to do it down the track.
Yes, it has to be that way.
Because it wasn't on the list, but and the other one was cat bans. The administering of that, is it, I mean, it's been mentioned in other evidence, but it's not on there. Is that an RPSL function in any way?
Yes, insofar as so in the absence of RPSL, you would have owners asserting their rights under each of the covenants between one another.
Yeah.
And so in this case, you'll have those owners able to do that, and you'll have RPSL also as a beneficiary under the covenant. And one would think, with a functioning administrative group, that's where you would go to try and iron out those issues among owners.
All right. And archaeological authorities, is that something that would be done as a 223 thing or just done separately?
Yeah, correct. No,
Good.
we don't think it's appropriate to kick those sorts of issues on to an incoming group of owners. That's a developer responsibility.
All right. Thank you. We've answered the question I had on 12. I was just curious about the balance land or the common land. Reading your evidence, it gives me the impression that there's some use intended of that land. I imagined it would be pretty well left as it is, or not to protect the.
So
Yeah.
If that's an impression I've conveyed, no, it's so the.
Well, you've even talked about potentially selling it. The owners would have to all agree if it was to be sold, and that's in your evidence.
I'm suggesting that agreement is a virtual impossibility, and therefore it wouldn't be something that was entertained.
Oh, I see what you're saying. Yeah, okay. So that's off the. That's certainly not intended. And it's, yeah,
you're disputing Mr. Vincent's suggestion about the QE2 covenant. You're saying that, if I read it right, that the power that the 33 lot owners will have would be even stronger than a form of QE2 covenants.
Look, I probably don't have the expertise in QE2 covenants to say that one would be stronger than the other. I suppose I'm asserting that I think that RPSL, the covenants among owners with the addition of RPSL holding it all together is a function as sustainably appropriate structure and provides the right level of control.
When it comes to the conditions, the panel could seek a classic no further subdivision consent condition, which would give you greater clarity over that.
Could do, yep. Yep. That's not inconsistent with the objectives of that common.
Nothing in there, Mr. Chairman?
No. That's right. I may have misread the evidence. What you've done, Mr. Garden, is you've tried to alert us to what could happen and how the provisions will prevent that from happening. Yeah. So there's no intention to use that land, that balanced land, that common land, if you like, because of the structure which has 30 individual owners all having to agree. But aside from that, it's going to be prohibited as part of the agreement that it can't be used or sold. Is that right? Because it's a fundamental aspect. It's a fundamental to this application that land is maintained. Yeah.
Under the incorporation of that ecological enhancement and monitoring plan as part of the formal land management structure.
Yeah.
That would be an ongoing protection. Yes.
Right. Okay. Okay. And there's one other thing, the biodiversity offsetting is is that managed through RPSL, the offsetting program, monitoring and.
Yeah, so again, there's an important distinction pre-2 or pre-tightening posts, and there's a wee bit of inevitable overlap of that, where the developer will have an obligation under ecological enhancement and monitoring plan to ensure over a number of seasons that there is a survival rate and that things are sustainable. So at the point of that handover, at the performance of all of the developer's obligations, it's correct that RPSL would assume responsibility for maintaining that offset area.
Okay.
And however, with the further subtlety that we believe, and we haven't really drilled into the weeds on this, but at some point, it's probably not necessary nor appropriate for RPSL, being Rocky Cliff landowners, to be jumping over the fence and with their spades and weeding and whatnot in those offset areas and benefit hills. So once they're genuinely sustainable, up and running their own ecosystem, thriving ecosystems, one would think that Rocky Point Services would sort of cease doing too much on other people's land elsewhere.
Right. Okay. If that's something that needs to be covered in conditions, I'd be interested in that, Mr. Brown, too. I mean, rather than thinking it might happen, if there's anything that needs to be controlled by conditions, we'd need to see those, but maybe Mr. Brown can talk to you about that. All right. I think probably the final question I had was the DOC private covenant. Would RPS yourself potentially be involved in discussions with DOC and making application to do things within that area and that sort of thing? Is that your role?
So we believe that almost always, in respect of the common area, RPSL would be a spokesbody for owners that would be appropriate, or individual owners would be unlikely to be engaging with DOC or any other regulator on common land, given that it's a 1/30 share. So their spokesperson would be RPSL. With respect to the fee simple private lots, that might be an individual owner.
Right. Okay, that's fine. I think that's all the questions I had on your part of it, Mr. Garden. So nothing further. Okay. Thank you very much.
Thank you.
Appreciate that. Mr. Cowan, yes. Yeah. Thank you. Right, thank you, Mr. Cowan. You may as well start now if you like. Thank you.
Wonderful, thank you.
Yeah.
Yes, so my name is Jamie Cowan. I'm a wildfire management specialist based out of Queenstown.
Yep.
I was asked and have carried out a wildfire threat assessment on the proposed Rocky Point development. The assessment weighs the likelihood of an ignition, the potential for fire to spread against the values that could be impacted by a fire. A wildfire threat assessment outcome found the threat to the development's future homes and residents and values to be high. Based on this, I proposed a raft of mitigation strategies that have been adopted by the developers. And these can briefly summarised, essentially following the FENS or fire emergency publications around factors as vegetation management, removal around buildings, low flammability plantings, low flammability building materials, and other factors that can improve the survivability of structures that be implemented. To work with Central Otago District Council to support the maintenance of the campground reserve below the development, to lower the risk of a fire travelling from this area to impact on the development. External vegetation and ember suppression sprinklers be installed, fire detection systems be installed, power lines to be placed underground where possible, a minimum of 2 vehicular access or egress routes always to be made available. The vineyards to the east of the property be utilised as a safe zone in the event of a fire, and activity trigger points be developed to manage ongoing activities within Rocky Point to minimise the potential for an ignition. The above recommendations were reviewed by Foreign Emergency on the 30th of October on the site visit and accepted as reasonable to manage the potential fire risk. On top of the above, Foreign Emergency also suggested that internal sprinklers be fitted to any future homes. I just had another point to add here that FENS was happy that the firefighting water supplies met the New Zealand standard.
That was in their tabled letter, was it? Yeah.
Yes, that's
Yeah.
right. Yeah.
Okay, thanks. Right, any questions of Mr. Cowan?
Things may have suggested that until sprinklers be fitted, but it can't make it compulsory, can it?
No. No, it's a recommendation, which is pretty standard across all new homes for FENS now.
Okay. Yeah. In relation to the paragraph 17, the most likely scenario is fire starting downslope. That's the most likely scenario. And in 25, in paragraph 25, you've said there are some limitations. There are some limitations, and your assessment takes into account other scenarios too, doesn't it? Yeah. Now
The
the other,
comment around the lower area there is that in the last 20 years, it's been 15 fires that were recorded in the fire emergency database, essentially in an area that could have impacted on the development. And the bulk of those were from the road and the highway road reserve.
Were they?
Below.
okay. Right, and in terms of paragraph 21, the setbacks, the buffer zones, if you like.
Yep.
I'd imagine you've thought about the consequences for the vegetation, and you know that's you've liaised with your other experts on the team on that one. Is it your experience that people who own these properties might seek an additional safeguard and just literally want to clear some vegetation, or is that something we shouldn't be concerned about in your experience?
People have very different perception of risk. Some of them have almost zero perception and couldn't care less, and others will be a bit uptight about things and want to go further. But I think, those controls, I guess, are implemented by RPSL. Perhaps maybe able to comment on that further.
It seems quite common to see wildfires on the news, and it's quite dramatic, isn't it? And it'd only be natural for people to think, well, I want more than sprinklers, But I guess that's to be managed through the agreements and contracts.
Honestly, it's 50-50 in my experience. People who really don't care versus those that can plan it.
Okay. All right. So let's see what else I've got. You've talked about the FENS. I was just going to ask you that question. The tabled letter from FENS addresses, it basically puts any issues to bed as far as they're concerned. Is that, have I read that correctly?
Yes.
And they're not appearing at the hearing. Okay. Let's just see if there's anything else. My breaks. Okay. I was just going to ask probably a question for the planner. Are fire breaks actually banned as part of the conditions? Are they specifically exempted or
Like further removal of vegetation would be exempted.
beyond? Okay,
Because,
indirectly. Okay,
Yeah.
yep. All right. Thank you. Okay. Very good. No, look, that's very good. Thank you for your statement, Karen, and you're welcome to leave if you wish. You're excused. You don't need to stay through the whole hearing, but it's up to you. Thank you.
Yes.
I'm not going to have any more questions. Thank you. Thanks very much. Yeah. Thank you, Roger. Standings. Yeah.
things that this has got the Jennings Hills online.
Oh, okay. Thank you.
Even
Thanks, soon.
I will,
not like just move those up. Voice.
Okay, I'll find this. Mr. Jennings.
Morning.
I'm looking over here.
You hear me all right?
Welcome, Mr. Jennings. Can you hear me okay?
Yes, fine, thanks.
He's on mute. Yep. What's the symbol for that?
Can you hear me?
Oh, okay. I understand it. Yeah, well, I'll try and find my. Thank you. Lost my statement.
Sorry, can you hear me now?
Numbers. Right. Can you hear me now? I mean, can you talk to us?
I can hear you fine.
Oh, okay.
Chris, I don't know if you can hear me, but I can hear you okay. So it looks, and I'm not sure if anyone else can hear, but it looks as though it's at the hearing admin end because the team seems to be working okay.
sorry, just a minute, I'll just see. It seems to be on mute there. How do I change that?
I could just hear Andy fine.
I just test out whether Andy or Sam or any of the other participants can speak.
Yeah.
Yeah, look, I can hear Chris. Chris, I can hear you okay. I can
It's
hear the
coming
admin
through.
people talking okay.
All right.
No,
If need be, we can take Andy Carr while we sort this out. But who can help with us? Do we need a technical person?
We could hear you. It's the case of finding the right.
Chris, can you speak for a minute?
Yeah, I can hear everybody fine.
Right.
Oh,
But it's not very loud.
hope we got some questions after all this. Yeah. All right. So we can, Mr. Jennings.
Yes, we can.
Yeah. Okay, Mr. Jennings, thank you. You might need to speak quite loudly, but we've got your supplementary statement and maybe you take us through that, please.
So you just want me to read out the summary?
Yeah, I think so. Yeah.
Okay. So I've assessed the effects of the proposed subdivision will have on the archaeological sites present in the project area, defined as Lot 1 DP 561457. Two sites are in poor condition and they'd be affected by the proposed development. In January 2023, I prepared the assessment report entitled Archaeological Assessment of Proposed Rocky Point Subdivision, Central Otago 2022. The DOC Senior Heritage Advisor, Dr. Matthew Schmidt, has noted clear deficiencies in the archaeological assessment in relation to the archaeological field survey coverage, the history of the Clutha Valley, and management options. Dr. Schmidt visited the project area and identified additional features, and he asserts that they are related to the water control network, related to gold mining. Dr. Schmidt has demonstrated his interpretation of this complex in his appendices. All additional features located or outside the development area will not be affected by the development of the subdivision. And Dr. Schmidt argues that the sites are in good condition based on his experience. Acknowledging that these features are most likely associated with gold mining, I concede that this would more specifically change their historic associations and contextual value in my original assessment. However, this context does not materially change my assessment of the majority of the values of sites G41/771 and G41/773. They have low information potential, they're in poor condition, and they have low amenity value, even when considered as part of this larger site complex. Without the provision of detailed exposition, such as signage, a lay observer would have not observed these features and understand them as part of a wider complex, or even that they're historic features. However, sites recorded with water races, dams, and reservoir features are common throughout Otago. There's over 560 sites recorded with dam or reservoir features on ArcSite, which is the New Zealand Archaeological Association database of archaeological sites. And there's over 2,500 sites recorded as gold mining sites in central Otago. In Otago. Dr. Schmitz found fault with the recommendations to manage the heritage as laid out in my assessment, and while I acknowledge that avoidance of an archaeological feature is a preferable approach in heritage management, it's not always possible. Site destruction is normally ultimately regulated by the Archaeological Authority process under the Heritage New Zealand Pohera Taonga Act of 2014. And as well as the sites in question are also relevant to the Conservation Covenant dated 18 August 2000. As set out in my evidence, due to the poor condition and low values of G41/771 and G41/773, these would normally be appropriately managed under a general authority to modify or destroy a site. If avoidance is an option, it should be explored. However, to be in line with international principles on conservation, such as under the Borough Charter 2013, this approach cannot preserve the feature without a consideration of its surrounding setting in the landscape. And isolating the feature and building housing lots around G41/771 in particular will impact the setting of the feature within the landscape, and it would not necessarily provide a positive heritage outcome. If recorded in detail prior to development of the subdivision, all of the archaeological features would be considered in their wider context. This information would then be publicly available and would potentially provide better outcomes for public education beyond simply retaining a feature in isolation. G41/771 and G41/773 will continue to degrade without intervention. Detailed recording of these sites prior to further development or degradation is an appropriate response to mitigating this destruction. Detailed recording of the features of those same features will preserve the remaining archaeological information of these sites. The remaining sites in the complex are outside the development area and would not be affected by earthworks or other modification. ArcSite, the New Zealand Archaeological Association's national inventory of archaeological sites, retains information on destroyed sites, so any contextual value of these features could still be evaluated within the wider landscape.
Thank you. I'll just see if we have any questions of fellows. Questions? Ian? Okay, I'll better ask some questions. Yeah, I was just going to ask a question, Mr. Jennings. We heard from, I think it was Mr. Garden said that part of this development, one of the values of the development, if you like, was to embrace or recognise the gold mining heritage. And now that you're aware that some of these archaeological features have a gold mining history, what efforts is the applicant making to embrace that archaeology in terms of either avoiding sites or reusing them or reinstating them in some way? Could you just summarise any sort of measures that are being taken on that score?
I don't have any specific measures to avoid to how they're going to. I'm sorry, I don't really have any specific details about that beyond retaining the existing features that won't be impacted development.
That's right. I'll ask the planners to discuss that one. In terms of some of the features degrading, they've degraded, and you say they'll continue to degrade. Is that degradation caused by farming on the site? For instance, is that the fast farming practices that have caused that? What I'm interested in is if the site was left as it is with no development on it and no farming, would they degrade with rain and other weather events? Is that what would happen? Or was it caused by farming?
I believe so. I believe it's actually multiple threats to it. So farming would have been in the kind of historic period a factor, but also rain. These things are earth features, so they're not built like, speaking about, sorry, the reservoir features in particular, they're packed earth, so essentially any kind of heavy water action is going to cause them to degrade. There's damage from encroaching vegetation and probably removal of the existing vegetation on G771 in particular, if not handled carefully, could cause further degradation. And also rabbits are a factor burrowing into the features, which I noted, I believe, in my site record during the assessment.
Right, thanks for that. No, that's fine. I understand that. Thank you very much for evidence. We've got no further questions. Thank you.
Sure.
So, right. Right, let's get ourselves organised here. What's power, is it? Perfect.
That's right, next first.
Just give us a moment to get out minutes and speak up.
Oh, you've got it?
Yeah.
Such face for some of them.
Oh, yes. Okay. Right. All right. Mr. Carr, still hear us? Yeah.
I can indeed. Good morning.
Right. Well, good. We can see you now. Welcome, Mr. Carr. Thank you for your evidence and summary statement, which we have now. Maybe just take us through the summary statement and we'll see if there's any questions. Thank you.
Yep. So in terms of the first part of the summary, it's really just a précis of qualifications and the like, and the scope of my evidence. Paragraph 3, my initial advice to the applicant related to the formation of the intersection of State Highway 8 and Bendigo Loop Road. And I participated in discussions with NZTA in respect of the improvement measures that were needed at that location. I've identified that can be upgraded to a diagram E layout, and that will be suitable for the traffic volumes that are expected. And I've spoken with NZTA in that regard. I can't speak for them, but they do seem to be comfortable with the proposed condition of consent that is set out in my evidence in chief, and hopefully has been carried through to the suite of proposed conditions.
Right.
In terms of the section 42A report, Mr. Vincent requested that a traffic engineer said that they were able to support the proposed gradient of 15%. So I can confirm that I can support that, and the reason for that is that it's aligned with the 2010 version of the overarching national standard 4404, which is relating to subdivision of land. He's highlighted matters of signage, railings and safety measures. My experience is they're typically dealt with when engineering approvals are sought. So that's a subsequent process after resource consents are granted. But on my review, there's no constraints to providing these within the site. Mr. Vincent has said, and I agree, that the increase in traffic means that Bendigo Loop Road needs to be sealed between the highway and the site access. And in paragraph 6, it's probably quite an important thing for you to bear in mind that at the moment the council is transitioning between two design standards. It has an addendum that has been based upon the 2004 version of the standard 4404. That has been through a formal process of adoption by the council, but at the moment the council is updating that addendum to reflect the 2010 provisions in that same standard. So we're sort of at the moment in a little bit of an unusual situation that we have a addendum standard which is based upon an outdated national standard but has been formally adopted, and we have a start of a process of that standard being, or that addendum being updated. So what I've said in paragraph 7 is that where we have conditions of consent relating to some sort of design, and that specifically refer to the council's addendum, in my view, there needs to be a degree of flexibility in there, because otherwise we have the application of an addendum, which quite possibly by the time that construction works begin is actually outdated and has no support at all from any authority. So I've suggested in my evidence in chief that it just needs to be a little bit of a tweak to the wording to say that either application of the council's addendum or some other standard agreed with the council engineers. Paragraph 8, something that I didn't mention in my evidence in chief, but just to advise that I have reviewed the internal roading layout for the site. I don't consider there's any inherent design deficiencies that are present, but again, the usual way of proceeding in these things is to do an outline design at this stage to show there's no problems, and then move through the engineering approvals process and the detailed design at a subsequent stage. Mr. Vincent raised the matter of visitor accommodation. That could change the traffic generation. I agree it could change the traffic generation. It probably would. But I've actually worked through those changes, and the same diagram E arrangement at State Highway 8 Bendigo Loop Road is still justified as the appropriate layout. And so, having reviewed the transportation aspects of the proposal and subject to those comments that I made in respect of conditions of consent, I remain able to support the proposal from a transportation perspective, and happy to answer any questions.
Thank you very much. I'll just check if we have any questions. Thank you, Mr. Carr. You seem to have resolved many things there. Thank you for that. I just had one question anyway about that condition that you're suggesting it's in your paragraph 47, unless otherwise approved by council engineers. That certainly gives quite a lot of discretion to the council's engineers. You're not worried about that condition being abused in any way, for want of a better word. In other words, you might end up with a worse standard than what was expected. Is that acceptable in your experience?
Yeah, I think there has to be a degree of reliance on pragmatism of the council engineers.
Yeah.
I think if we strip it back, the first concern that I would have is the current wording, which says the application of the council addendum, because the council's own website itself says that they are going through the process of updating it. I've spoken recently with the council officer who said that work is underway. So I'm firstly concerned that we don't end up having to apply a standard, or an addendum rather, which is out of date. The second thing is if that's the starting point, I know that we can't have a condition of consent that relies upon a forthcoming standard or forthcoming addendum.
Yes. Yeah. Okay.
So what I've got is the least worst option there.
Yes.
It's possible Mr. Brown or someone else will have cleverer wording than I as a traffic engineer, but I do think we can have a reasonable degree of reliance that the council is not going to go completely left field and want a 6-lane highway serving the site or something like that. I think if they have a newly minted addendum, my experience of council officers is they're always very keen to ensure that is applied rather than coming up with something off their own bat.
Right. Okay. Thank you. And just in relation to your 57 in the conclusion, I just wondered if you need to include the sealing of that last section of Bendigo Loop Road as one of the mitigations, or was that not a safety? Is that more a tidying up the road situation there?
Yeah, it's more of a tidying up the road. There is, in my view, a justification for the sealing of the road. The sealing of the road, again, is something that would fall within the new addendum rather than the old addendum, or potentially the 2010 standard. But yes, I do agree that probably it would have been clear in 57 to include the comment about the sealing in there. All right,
thank you. Look, we've got no further questions, but your evidence has raised a couple of questions that I have for the team, for the applicant's team, which I'll put to Ms. Hill now, because I think we're ahead of time, which is great. So thank you, Mr. Carr. You might be interested to hear the question anyway. What I'm interested in is a visitor accommodation. I haven't read too much about that, but does the consent for visitor accommodation, does that essentially mean like Airbnb, people letting their houses out to people to live in, or is it? It's not motel type accommodation, is it? Is there any? Yeah, it's the former. Okay, so the consent would allow any of those lots to be used in that fashion, or permanent residents, either or. Is that the intention? Mm. Yeah, applied for it. Yeah. It appears to apply to them. But
Yeah.
Yeah, I just need to confirm the condition with you. Can we come back?
you can come back on that. Certainly from Mr. Carr's point of view, he said that if it's visitor accommodation, they have a lower traffic generation, so it doesn't impact on his assessment in a negative way, that's for sure. That was the first question that we'd like clarified, and the second one was, I understand consent's been applied for earthworks as well, for the building platforms and driveways and all those sorts of things, but I don't recall seeing any assessment of that anywhere in terms of the volumes or the visual impact of those things. And it's possible that's covered by some sort of management plan, which I'm not totally familiar with, but if we're being asked to grant consents for quite large scale earthworks, I think we need to know where the assessment is on that. So that may well be, yeah. And my apologies if I've missed that amongst the detail, but yeah. Yeah. All right. Now look, that's all we had from Mr. Carr. We're a little bit ahead of time now, so. Well, we could either adjourn now for lunch, or we could take another witness. But yeah,
Could be an opportune time for the block to just take a
refresh. Yeah, let's do that. Yeah, let's do that. Okay, that's good. I mean, there's some big topics still to come, but yeah, let's take an adjournment now then, and we'll come back at 1 o'clock. Thank you, everyone. All right, we'll reconvene the hearing, folks. I think we made good progress this morning, so thank you all for that. Right, we'll hand back over to you, Ms. Hill.
Okay, so I'm just going to make 4 points in terms of housekeeping.
Oh, sure. Yep.
The first one was just in response to your question being aware about which elements are enabled for traveller accommodation.
Yeah.
So that's all of the lots, save for lot 24 and 30, which are all the mixed use lots.
Oh, yes.
Question 2 was in respect of assessment of earthwork effects, and Mr. Baxter's going to talk to that in his summary statement as well.
Okay.
And the third point was a question around the trigger for the non-complying activity status.
Yeah.
And that coming about as a result of allotment setbacks, and whether that was a design response or
Yeah.
So,
Was it setbacks or minimum lot size? Yeah. Yeah. Both. Yeah. Okay.
So Mr. Bex is going to address that point as well.
Okay.
And then the fourth point is just a reflection that I think this morning we've talked a lot about the intentions of how the subdivision will be carried out, and it's becoming increasingly apparent that this is a consent where absolute certainty in conditions is really critical to have an assurance that that is what is going to happen on ground.
Yeah.
And some really good questions about, what is down the track. Individual 30 lot owners. Yeah, so we've been working through the conditions over lunch and continue to refine those. And I think it's going to be really valuable if we have a detailed step through session on that tomorrow morning when we go through Mr. Brown's.
Absolutely. Yes. Yes.
So get excited, I guess. Thanks.
Yeah, no, we always intended to have a detailed work through those, because they're quite hard just to read. It'd be nice for someone to take us through them.
Yeah.
So,
and talk about sort of the threat mechanisms, really important.
Yeah, definitely.
It's not registered and there's been some really helpful observations this morning, just causing us to reflect on fine tune that as well.
Okay. Yep.
So, okay, thank you for that. So I'll hand over to Mr. Baxter.
Thank you. And just before that, at the end of the day, we'll have a chat about the site visit too and make some arrangements there once we've finished. Yeah.
Yeah, good point.
Mm.
Yeah, good point, because it may well be that we did slightly early today, and so, yeah, that's something that's technical today.
We'll have a look at that, yeah. Okay, thank you. All right, so Mr. Baxter, thank you. We've got a summary statement, and I've got two other statements, but is that right? Yeah, you'll take us through that. Yeah. Okay, thank you.
Right, Paul Morrison on my left, one of my colleagues in our office, and he played substantial hand in developing this site.
All right. Yeah. Okay, welcome, Mr. Morrison. Yep.
Any questions arise? Just to say, I've been working on this since November 2021. So, second paragraph. My role has been assisting in the master planning of the proposal, the development of appropriate design controls, and working with the consultant team, and then amending and developing the master plan with the input of the consultant team progressed, and the preparation of landscape evidence including site walk and site visits. I don't think I need to, on paragraph 4, already described that fairly comprehensively. My role, our role has been working closely with them and advising and designing a bespoke design solution to the site, including the siting of dwellings and structures on areas where potential effects on the existing vegetative cover is minimal. Through part of that process, through capacity of the master plan site, I've been aware of the potential adverse effects of the wider that could arise in the wider landscape character of the surrounding landscape. That may arise from this proposal, ensuring that those potential adverse effects are minimised and critically advising on design controls that aim to assist in the visual absorption of structures into this landscape. But I think it's I'd just like to dwell on it for a second, because the assessment comes secondly, but this has been a design-led process through and through. We weren't given lot, locations, sites by a surveyor engineer. We led the process the whole way through. So it's been tailored to the site. So really, the design part of the process and that consultation with the crew and enabling and finalising that design has occupied 75% of our work program through with the assessment followed.
Yes, I'm glad you raised that, because I was going to ask a question at some stage about how you've worked with the rest of the team and what your brief from the developer was, and you've been influential in the design right from the start.
Yes, right from the start. Well, this was a design-led process, and I'll go into that in a bit more detail shortly.
Okay.
The proposed design controls, they're attached to my primary evidence. The design controls are extensive and fundamental to the conclusions that I've reached in my primary evidence. I'm particularly regarding the scale of potential effects arising from the development. The detail in the design controls far exceed the standard scope, detail and scale of controls attached to most rural developments in this district. I have written extensive design controls for developments throughout New Zealand, from Millbrook Resort to developments in Taupo, Hawke's Bay, Auckland District, and many others by way of example. In fact, I'm currently doing ones in Orewa, Waireki Golf Course, and these are projects for market. The level of design control details included in this application are a reflection of the complexity and the sensitivity of the landscape of the site, and are certainly some of the more complex and site responsive controls that I have advised on and constructed. Just going through it, and I just want to make an analogy on this one, particularly with the 3.8 metre high dwellings. We've been working for 5 years now on the Hogan Gully Farm Resort, new one over in the Wapiti Basin, which is now under construction. That development, we came down, I worked very closely with Andrew Patterson, and we developed up they're all 3.8 metre high buildings, dark buildings. 42.5 hectares of native revegetation at Hogan Gully Farm, which is the largest private revegetation project about to commence, and that has to be established before we start this job. with the vegetation in place for one of it, doing simply. But that 3.8 metre high buildings, we're picturing long high buildings, and the design controls are incredibly specific, particularly the ones with on lots 1 to 10. And on 24 and 26, which are the ones outside the recreation zone.
Right.
Yeah, where the roof pitches slope down towards the view on all of them. So you start at 3.8 metres high will be the highest point, but to get that
Yeah.
slope, you probably end up at 3.4, 3.3
Right,
at the
okay.
front. So they're long, low, dark recessive buildings. And I think that's important to note. The key components of the design controls can be summarised as follows. On general, the dwellings potentially visible from further afield will be low, 3.8 metres in form, dark coloured with monopitch roofs, and that pitch dropping towards the viewpoints. So it's very important, we don't have 3.8 metres of glass that drop down, which forces the glass down. The amount of glazing and the overhang, the veranda, the eaves are all in the design control. Site coverage, building footprint, sizes, that's restrictive in scale and tailored to each site. And that probably comes back to a question that you asked earlier about minimum lot size.
Yeah.
And it's something we've run up once a lot. I've been involved in many master plan neighbourhoods throughout the country that may have a 4 hectare minimum, but we end up with houses 15 metres apart. And we spread the 4 hectares out there, but we put a no, basically, you go through the motions. If we went for larger lot sizes, 4, 6, 8 hectares, and I understand that the complying number is somewhere in the order of 28, but Mr. Brown's talked all about here, we're talking about that. Then the opportunity for adverse effects on existing vegetation, controlling earthworks, etc., is all removed by making them smaller lot sizes. That footprint, by footprint, I'm not talking about the actual footprint of the building. I'm talking about the footprint of effect. Is concentrated in areas where we can work on it. To that end, we developed the site contouring works have all been done by our office first, and then sent in CAD to the surveys for the volume calculation. And so the site contouring has been done at a minimum of 1 and 3 grade. So it's all walkable and mowable, and also manageable. It actually requires slightly more earthworks than what's required if we have a cut batters and retaining walls, but we didn't want that. We wanted to have a slightly softer approach to that. By having a 1 and 3 grade and those sorts of grades, it means you actually take up more room. So that's why we've made the building footprint smaller. And if you go on my attachment M, so I made 3 copies if you like.
Oh, which one was it? Sorry.
Attachment M.
Oh, attachment unit. I've got 2. Just one of them. No, there's a good thing. It's mine.
That's
Oh, I got
this
it.
one.
Oh. Put that in hard copy for another. These are all good ones. Oh, okay. Yeah, I don't think.
You want a big one?
Yeah,
that one.
Oh, that one, yeah.
Yeah.
Oh, attachment. We've got some.
And so I've only got my spare copy.
Yeah, I'll bring it, yeah. Which one is it? This is a lot better.
I just wanted, and I'm not, I wanted to speak to you quickly, but just to take you through the thought that went into this. So you can see, for example, lots 1 to 9, or 220, 200 square metres maximum building size. Now, that's not considered a large dwelling, but it's still got a quality dwelling under that. Those ones you'll see from numbers 1 to 10 are 3.8 metres in height. Those are the ones that are potentially visible or will have views out southwest over Lake Dunstone. Then we go down lots 25 and 26. The two lots that, or 26 in particular, 26 being outside the recreation zone and within the O&L, and potentially visible from distance to the north and approaching from the Lindis direction. Those are 3.8 metres as well. The larger, the taller buildings are all contained within the valley, by want of a better description, that runs through the middle of the site, which you'll see on the site visit.
Okay.
So you can see that these have been tailored fairly specifically to address the lot sizes.
And Mr. Baxter, just while we're on that building height, I read in the 42A report that your way of measuring height might be different to how the district plan does it. Is that right? Yeah.
These are flat building patterns.
Right, okay.
So they're a floor dated, and I've been caught in that so many times by rolling height plane, where we promise something and they cut it out and have another 3 metres of building height. These are flat.
These are data.
Floor level.
Yes.
The highest point.
Okay, thank you.
Yeah, so all the platforms have been all the contours show level building.
Yeah.
While we're on, and I think answering another question if it was where we're on.
Yeah.
My attachment C, the Rocky Point recreation.
Yeah.
I can't give you too much more information. So on this to say, aside from the fact that I drew that in 1995 and I was 35 years old. When I was working off this. That gives you an idea. That was a long time ago. I was working under the guidance of Alan Rackham, and I'm familiar with Alan. Was one of the directors of Optimus, from highly regarded landscape architect, landscape planner. He's been retired for 50 years in Cornell. If my recollection was that the shape and form of that zone area was to follow the valley that runs through. You'll see it on the site, and it's described in one of my the upper valley and part of the plateau area. It was to accommodate that, and that containment within the landscape actually spills out slightly on each end. So if we come back to my attachment A1.
Yeah.
We highlighted that in a thick dotted line.
Yes.
That is the overlay of that zone drawing.
Right.
From what I understand, if looking at the top again, the attachment says is an area designated for travellers accommodation clustered dwellings subject to the recommended rules and design guidelines within this report. My feedback to the planning officer, we can't sue ourselves. No one's been able to find that.
Right.
From what I understand. Yeah.
Amazing how things go missing, isn't it?
We'd like to, even, I mean, it may be buried in the depths of the bottomless archives, but that was out of the Queenstown office, which is then closed down about 6 or 7 years later. whether or not files are moved up to Auckland's, and we've had no luck in trying to source that.
Right, okay,
But the intention was to allow, my recollection, the intention was to allow well-considered development within the particular area.
Yeah.
And with a reasonable degree of protection over the rest. And I can't put in any more detail
No.
than that, I'm sorry.
so you didn't, I didn't quite get, did you physically draw that yourself? I think you said,
Yes.
that, yeah,
Yeah.
did you paste the site did you go out on the site?
Yes, yeah.
So it has got some,
Oh, yes.
scientific
Oh,
scientific basis.
I wasn't just.
Yeah. Okay,
Yeah. Mm.
all right, so the next question will be why are you developing outside that area?
Oh.
But I know you've got evidence on that, so that's principally what we'll be interested in, yeah,
Yes, yeah.
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 okay. They will
Well,
come to
yeah. Well, I should answer that question now.
in general, you could, but you certainly got lots of evidence on it, so that's,
Yes, yeah, and it's been a design-led site responsive process where we have stripped out some of that. On my attachment A1, there are a couple of little areas, but like number 20 and 21 just step outside it. But those are within.
Yeah.
And absolutely contained little valley. And as you can see, it's a reasonably blunt line, like a lot of ONL and zone boundary lines are.
Mm.
But I can confirm again that that was the intention of the.
okay, no, I think that's probably enough.
Yep.
Thank you for helping with the genesis of that document. That's useful to know. Thank you.
Yeah. Yeah, so the design controls are fairly straightforward with that. Questions about the body corporate, just, and I've just got notes responding to your questions about that, about Mr. McPherson asked how effective they can be and what if you have a neighbour that doesn't like doing it. These, from my experience, and I sit on the design review board at Millbrook, have been on that 28 years, and run the controls there, Jack's Point and Mount Cardrona, for example. These are self-policing. People buy into it. And we have seen to the point in Bendemeer where people get upset they can't do what they want to. They've sold up and moved on. They do work, they are self-policing. You have to get the consent of 30 other neighbours. They work. And that's all I can say. And to be honest, the retention of the vegetation and site character and the approach is what maintains the capital values of these lots. But people don't want them played with.
Okay. Well,
Okay. I'm on page 3, sir.
Yeah.
The landscape controls are contained within specific curtilage areas. Plantings in Kānaka only, or a short list of native dryland species are set in the controls. A very small area, 6 by 5 metres of non-specified planting is allowed, and that's to allow a herb garden or a vegetable garden. Yeah. So the plant's incredibly restricted. So in summary, the design controls are extensive, restricted, and relevant to the setting. Landscape character. I agree with the comments of the planning officer in the statement that the bar gets higher in terms of reduction and mitigation of those buildings, and he's talking about the ones that view over Lapplands, especially those proposed dwellings that are A, within the development area and potentially visible from Lake Tunstall, B, those outside the development area and potentially visible from more than viewpoints looking into the site. I've written extensively on that. I won't go into that. Landscape character is a distinct combination of landscape attributes that give a given area its identity. I've discussed the components of landscape and agents. The proposed development introduces a low level of change in the landscape character, a low level at the wider macro scale, acknowledging that at the micro scale there will be pockets of substantial change, such as in the locale of proposed lots 1 to 10. However, this is somewhat anticipated as this is located within the Rocky Point Recreation Zone, However, come back to the level of sign that's we put into those. The bulk location and scale of the development combination with proposed design controls will avoid and mitigate any adverse effects through the overall macro landscape character being that visible panorama. The proposal changes portions of the environment, but will not degrade the quality of the surrounding environment. And the scale of the development appearing as a logical extension of existing residential development south, which is successfully visually absorbed into the landscape. And those wider viewpoints, especially from the surface of Lake Junction and from wider views, which I may say 1.5 to 2 kilometres away, I consider that the scale of any potential adverse effects on the landscape character will be low. I also found the same conclusions on dwellings in proposed lots 24, 25 and 26. Landscape amenity is the natural and physical quality and character of an area, brackets landscape, how that contributes to people's appreciation of its pleasantness, aesthetic coherence and culture and recreation influence. I acknowledge that the site has a significant level of amenity, providing a natural landscape backdrop to Lake Dunstan and the landscapes of Clutha Valley and the environment. So although the site has a high level of amenity when viewed from Lake Dunstan and the flats of Bendigo, the proposed development will complement the character and quality of the application site and surroundings and will be difficult to perceive from wider views and will not adversely affect the aesthetic coherence of the landscape, both within the site and the wider context of the site. Therefore, overall, the proposal will extend to a low level of change on landscape amenity with low adverse effects. Where development is visible along Bendigo Road, this development occurs within a tight cluster of existing development adjacent to the Bendigo Station Homestead and other existing established residential property. This does not occur in an area of the site which displays the natural characteristics of the wider site. I've addressed the relevant objectives and policies pertaining to landscape and rural amenity values contained in district plan in my evidence. The proposed development will generate a low level of change on the landscape character and amenity of the site. The proposed bulk and location of building platforms and prescriptive design controls will avoid and mitigate any potential adverse effects that the development would have on the natural character and amenity values. With regard to the O&L, the extent of effects to the standing natural landscape is expected to be very low. Their overall level of changes seem to be very low, and the proposed development will create less than minor effect on the values of the O&L, and those values will be protected. The existing Rocky Point recreation zone appears to loosely follow. I'm sorry, I've described this. I probably don't need to do that one again.
No,
yeah, and I think my conclusion comes out of that from evidence in here. Can I just say, I think the best example of what we're talking about here with these buildings, and we've been involved with two of those ones, subdivision occurred on Northburn Station, which you drive along, you're heading up and you get glimpses how.
Yes, I did see that yesterday.
Yeah, yeah. But if you go to the other side of the right west side on the Luggett Highway and look back at those, that's the effective ones that we are talking about on the site. I think those are quite a relevant scale.
Right. Right, so thank you. Thank you for that summary statement. We've got your evidence in chief as well. We will have some questions. I'll just hand over to my colleagues first of all. Ian, do you have any questions? Not at the stage, and admit we haven't sort of done a proper site visit, so we may not have a lot of questions just yet, but
So I will be back here in the second half. Thanks, so I'll be available.
Oh, you will, okay.
Later on if you want, so.
it's possible that could happen, yeah, okay.
Have you done somewhere, correct me if I'm wrong, it wasn't real, but about restricting the amount of glazing? And
Yes,
How does that work practically when somebody wants a view?
Oh, it's
They want a
quite-
big picture window overlooking the lake.
I don't restricted it so it can only cover 50% of the facade, which is still quite a lot for us. Yeah,
I'm just about light spill and, dark skies and.
It's something that I run into all the time. I mean, really, those pinpricks of light that you may see very much driving up the road, two kilometres away are on the lake, and it's probably not good boating trips to be on the lake in the middle of the night. But are literally pinpricks, and I run into this all the time at hearings. And I think you have to balance. You have to balance an emotive response to lighting to reality. Those are little pinpricks of light, 1.5, 2 kilometres away. Light spill, night sky, it's not going to. I've seen prior evidence with Marshall Day addressing this. Out of Auckland, I'm not Marshall Day, the lighting price. Yeah. And it was basically, it was to the point of virtually negligible effect. 1.5 kilometres away. And we do have restrictions on downlighting for exterior lights.
Thank you.
Well, I've got some questions that I can ask you now. Thank you. Sorry, you're still going now. Yeah. I just, was there originally only one access into the site and now there's two? Is that the 4 lights down the bottom? Was that for fire purposes?
There is one access into the site.
There's only one.
But there's an opportunity, it's just a farm gate and it goes out.
Oh, I see.
And, there's the opportunity for fire egress to cut out, to evacuate out to the east.
Yeah, and there's also exits up through, what's known as Bendigo Hill, so there's sort of 3 exits.
Oh, yes, and south as well.
That's right. There was another one that showed for future access or something, a future development, I think it said. It's, okay, so that's all right. Okay, thanks. I've got some questions just in relation to the 4 lots down the bottom on Bendigo Loop Road. You've now, and I've seen those because that's one thing I did see on my brief site visit. The poles are up in sight and that's quite useful. So thank you for that.
And probably best to look at attachment 1A.
Oh, yeah, I've got them on A and yep, and so there's one additional lot there from what was originally proposed, and you've also amended that to provide some concept planting in front of those lots to address Mr. Vincent's concerns about those. What I was going to ask you was, in terms of the character, you've made the point that it's sort of a continuation. I think you said a continuation of viticulture and other stables and some other development along the flats, if you like, the lower parts of the site and the environs. But the stables area is marked by huge trees that sort of is quite a, I mean, I know you can't go planting trees that size, but this would be quite different planting to that, wouldn't it? And do you think, what sort of planting did you have in mind for that area?
Well, there's a plant list on there.
Yeah. And
the plant list within the lots is fairly thin. I would have no problem in throwing crow's nest and Lombard.
Oh, I know.
But it would actually complement the other side quite nicely.
But I think the concern would be that, and I think Ms. Lucas has made this point too, that the stables are quite established and almost hidden by huge trees, and these would be brand new buildings with new plantings. And can you really describe that as a continuation of existing development? I mean,
no, well, you couldn't say a continuation of what's called
extension of it. Yeah.
It was a continuation of a modified landscape, but not the same look.
Right.
Those buildings in there are all 5 metres high.
Right.
So they're single story and subject to the same design controls. Bearing in mind that attachment 1A shows mitigation planting, which is soft in the foreground, but they're not really to screen buildings. But bear in mind that mitigation planting will by default extend in amongst the lots, because that's the only planting they can continue into the lots as well, so.
And they, from my casual observation, there seemed to be a sort of a gully that runs down there, and I couldn't tell where the boundaries of the lots would be, but would the buildings be sited up on the back hill slope?
Oh, yeah.
Up on there?
On 1A, so and see above lot 28, you can see the gully there.
Right,
And these were, and we modified it, didn't we, Tom, in response to the overland flow plan.
right, okay, because it does look like that. Yes,
Oh,
it does look like, yeah. Okay.
Cloudburst could get filled wet, so they've been brought back and above.
Okay, and I did notice that the vineyard, there might be two vineyards there, is there? There's certainly one on this side of the road, and there might be one on the other side too, but there appeared to be at least two dwellings high up on the hill that are actually quite hard to see, because they're quite recessive, but they're quite large buildings. And there's some other structures up in that area too, aren't there? The shed.
There are other structures.
Is it shown on one of your viewpoints, is it?
No, it's off the viewpoint, isn't it? On,
Oh,
it's further along.
Okay,
Yeah, it's further up to the west, probably 3.83.
we'll have a look at that. We'll have a look at that.
Yeah, and A2, you can see it.
A2. Oh. Okay. Oh, that's right. That's only one.
Yeah. There were 4, 5, and 6 lots up in the gully.
Yeah.
Up above the cattle beach, photograph.
Right.
That left hand end up in
Yes.
there. But bear in mind that those ones are probably 5 or 6 metres high there. They're larger in stature than the elevated ones that we see on, in particular, 24 and 25.
Right.
26, 24 and 26.
Okay. All right. Thank you. See if I've got any other questions. Actually, that one. Yeah, I was just interested in your assessment that it's a low, I think you called it a low visual effect. And the
From those 2 viewpoints.
of the whole, sorry, going back to away from the bottom ones, from the whole development as a whole creates a low visual impact. Is that?
I'm still comfortable with that because unless those houses are, the stature and that, I think unless they're pointed out, these dwellings with what we've done in our really restrictive dark low buildings set amongst the dark complex Arnica. You won't notice it. They'll be very difficult to perceive. It was only on that basis I was able to. But of course, the design controls allowed us. Well, that was the goal we had. Yeah, to come out with that system.
Okay. And the impact on earthworks and tracking and vehicle and driveways and that sort of thing. Ms. Hill told us you were going to address that if you got any particular comment on that. I mean, as I understand it, we've been asked to grant consent for quite extensive earthworks.
The earthworks up on the top, once you get into the practice, as I said, have all been shaped. Yeah, they've all been shaped, so there's no cut batters. And cut batters in that climate will be impossible to revegetate.
No cut batters?
It's
okay.
Northwind Station's got the lowest rainfall in New Zealand. It's dry. So care's been taken that will ease in that aspect to make sure that they can be managed.
And the main road that leads up, the access drive that leads up, same comment applies?
Yeah, same comment, but there's already cut batters.
Yes, there are.
Access road, so.
you're just using the same alignment?
No, it's not.
No.
It's slightly different. It's slightly different, and we can't. Might be, probably the best way to look at it, but it's no better, it's more than what already there. And the best way to actually mention that road is to look at the photographs of what's and the effect of the current road.
The existing track's been covered for some time, it's felt cut there, it's really undesirable and fairly steep, so we're looking to straighten that up.
Yeah, it is quite steep, yeah.
Nice consistent grade of about sort of 13%. So it'll all be asphalt, equivalent with Gavin. Asphalt count.
Asphalt.
Road Gavin, and a better and dressed up appropriately. Somewhat so the road and what's up to the long face now and up to skate race.
Yeah, except no curb and channel. Yeah, we have a flush no.
Yeah.
And I think that's something that, I'm not sure if it's in present conditions, but it's something I'd like to, that's which is a standard, but you know, but not so,
Yeah.
you don't see that curb and channel with white line. Yes.
Okay, that's fine. Look, I think, I don't think I can ask you many more questions until we've done our proper site visit, but you've answered the key principal questions about the design-led aspect is interesting, and you've clearly done a lot of work on each building platform and how it fits into that, and you've got particular controls bespoke for each site, and they're the key points I've got at this stage anyway.
So the simple case here, if you, I've kept up to obviously, but I haven't got appointments for the next few days, so I'll just work around and you've been.
Yep.
That, isn't it?
Yeah, I'm just starting to think we're getting through this a lot quicker than I thought, and there is a potential to go up to the site like now or soon, because I think it'll take us about 3 hours to do that. I'm just trying to think that through. If that happened, we'd do ecology in the morning, and Mr. Brown, I think we could do all of that in half a day. Any thoughts? Does that suit you guys with your arrangements or not? We'd rather
I'm pretty relaxed.
Yeah. Mr. Vincent, you've got a car booked, I believe, haven't you? But we don't know if that's available.
I had one Wednesday morning.
We might just take a brief recess and just, if people can just let me know if that causes any difficulties.
Okay, I just suppose maybe we get the servicing in
Oh.
yeah.
Yeah, look, you're right. Yeah. My apologies. I've forgotten about servicing. I thought we were going with apology. No, we will carry on with that. Yeah. We'll carry on with that and have a brief break. Yeah. Okay.
Well, I think it's probably not any questions, are there?
Not many, no, not many, because yeah, I've got some, but I don't think there's many. So I'll just find those and
I think we'll call, both of the TKO experts together. That's what's going to be in this one.
yeah, sure, that's fine.
Thank you.
Yeah. So, still moving. And still moving. No, that's all right. They may not have any.
Okay, so, yeah, it's not just be easy for the team approach again as well.
Absolutely, yep.
And, each of them have, short summaries as well.
Okay, yep, sure.
I think,
Thanks.
Thank you.
Almost that. Fine, yeah.
Thank you.
Are you going? Okay, right. I think we're okay to proceed now, Ms. Ryan, did it? Yeah, Ms. Ryan. Welcome.
Thank you. Before I start, there's just one that I want to clear up in my evidence and piece.
Yep.
That first exhibit, which is a stormwater management plan addendum. Unfortunately, the PDF didn't include the appendices.
Oh, yeah.
We do have copies here of detailed calculations, which I forwarded
Oh, I see.
do. But here is 10 copies if you would like them.
They may not mean a lot to me if they're calculations, but we'll,
Yeah.
we should have one for the record. Yeah, yeah. Yeah. Okay.
Just here.
No, just send them through. Yeah.
Okay,
Yeah.
and the first appendicle was the master plan, which was dated 29th
The
of
one?
August. Yeah.
Okay.
And that appendix, which you have in my evidence.
Yes.
Anyway, so it's all
Okay.
good. So I do apologise. It was just when I was
No, that's fine.
checking through
Yeah.
everything.
Okay.
How many double checkings can you do, you know? Right. So I'll just start with my summary. Unless there's some questions of evidence of chief, but
No, just start with that. Yeah.
Yeah.
Yeah. Yeah.
okay. My name is Bronwyn Patricia Ryan. I'm a director and environmental engineer at TKO New Zealand Limited. I have a New Zealand certificate in civil engineering, a Bachelor of Engineering and a Master's in Environmental Engineering Science. I am a Fellow of Engineering New Zealand, a Chartered Professional Engineer, registered with both Engineering New Zealand and International Professional Engineers. My professional expertise lies in water resource management, particularly stormwater treatment, disposal management, and flood and flow regulation, spanning over 20 years. I have substantial experience working projects across New Zealand for land development, local government, and private sector clients. My scope of evidence and stakeholders concerned. My evidence addresses the critical aspects of stormwater management and flood risk, considering the site's unique characteristics and potential effects on the receiving environment. Several stakeholders, including Iwi and Department of Conservation, Whakaputahi, and other individuals, have expressed concerns about the project's potential environmental impact. These concerns primarily relate to the potential effects on water quality, indigenous vegetation, and overall character of the landscape. Just a summary of the stormwater management. A comprehensive stormwater management plan has been developed for the Rocky Point subdivision to address and mitigate potential adverse effects. This plan is based on detailed hydrological and hydraulic modelling. The SNP outlines strategies for managing both primary flow from the initial runoff after a rainfall event and secondary flow conveyance with the management of stormwater after it had been collected and treated. Although the development is considered low contaminant generating, the SNP includes measures like non-contaminant building materials and incorporating swales, which are the shallow vegetated channels that you see roadside, designed to manage stormwater runoff and improve water quality. And just a summary of the flood risk assessment and mitigation. The flood assessment identified 5 existing overland flow paths traversing the site. These overland flow paths can be accommodated within the development layout. However, one overland flow path associated with an existing watercourse adjacent to Bendigo Loop Road requires slight modification to accommodate lights 27 to 30. This modification includes maintaining the existing entry and exit points of the watercourse to ensure no upstream and downstream impacts on the flow conveyance. This means that the modified watercourse will continue to carry the water in the same way as it did before, preventing any changes in flooding patterns on adjacent areas. The watercourse modification will include culverts for road and driveway crossings, allowing for safe passage of vehicles while still enabling water flow. Flood modelling demonstrates that proposed development will result in minimal changes in flood levels downstream and will not impact the operation of state highway or adjacent land uses. Addressing specific stakeholder concerns. The SMP is developed to provide best practical options for the site to be developed in a way to ensure that effects of water quality and quantity are minimised, helping to preserve the Māori of the water. To achieve this, SMP incorporates various measures, including but not limited to strategic placement of structures to reduce water velocities and prevent soil erosion, use of inert materials to minimise contamination, provisions of swales for treating runoff before discharge. Stakeholder concerns about potential stormwater runoff onto the state highway are addressed by a flood assessment, which provides assurance that the highway will not experience increased flood risk due to the development. Additionally, the necessary intersection upgrade will adhere to the SMP principles, further minimising any potential impact. The Section 42A report raised concerns about potential changes to stormwater runoff patterns that could affect saline areas, particularly lots 23 and 25. While the SMP outlines general mitigation measures, the location and design of discharge points will be carefully determined during the detailed design phase. This stage will address the concern of changes in runoff patterns by ensuring that runoff from impervious surfaces, such as roofs and roads, is discharged effectively while protecting the sensitive saline areas. That's it.
Thank you for that. See if we have any questions.
In your planning for stormwater management, what thought or considerations given to potential changes due to climate change? And as we are seeing more large rainfall events in this part of the world than we have in the past. I'm thinking of some of the incidents which have happened in Roxburgh recently, where we've had some pretty damaging down, we call them thunder pumps. Yeah.
So whilst we go by guidance from the NFB Ministry for Environment with regard to the climate change assessments that we are working within the bounds and also New Zealand standards, there's also the ability for us to assess where the water will flow to, given there is a climate change, prediction. And so it's quite unique in this property or this development. There is actually 5 overland flow paths, so it disperses the effect. More as that can these overland flow paths accommodate the increases in rainfall that we have been experiencing, what you just said about Roxburgh. These lots are placed so they are away from the flooding, away and given freeboard to the building platforms, and then of course the buildings are above there. Notwithstanding that, there is a lot of room in here, and it's very close to the receiving environment, which is the living, of course. So when you're looking at this with the increase in climate change, the surface water will effectively be able to disperse to the receiving environment fairly quickly. I think
it's pretty dry.
It's pretty dry. Yeah. The most damaging effect is when you get the rainfall events that occur, one after the other. So you get saturated soils, and then you get the runoff, and then this development, this site in particular, it's very quick to come down to the flats. There's a lot of area there for it to be able to be accommodated in it, or it goes into the inclusive river.
Thank you. Thank you very much. Just take your point that you've worked in conjunction with the rest of the team to look after the ecology, the saline areas, and you've designed as best you can to meet the concerns of stakeholders. I think iwi remain opposed to the development, but you've attempted to address the concerns I've expressed through their submission. What I was interested in, it may be more of a planning question, is I presume regional consents will be required for discharges, and at that point, I think you've made the point that design will be, you've done the SMP, is showing the best practical option. The detail of the discharge points is to be determined through the next stage of design. I'm just hoping that a regional council process will pick up the concerns that are raised with respect to the site, in terms of the saline areas and so forth. I'm not sure what their considerations are when they consider resource consents, but I'm hoping that will be picked up. It's probably a planning question. And also another planning question is how the stormwater management plan is given effect to through the, how it's implemented through the consent conditions, but that's not for you maybe, but
Yeah.
but have you seen the draft conditions and are you happy with those? Have you?
So I haven't, not
Okay.
specifically, but
okay.
that we do work in conjunction with everybody else in the team, and so
Good.
that's why
Okay.
in this, I'm recommending that the SMP has been adopted.
Yeah, no, that's fair enough. Well, but no, I think you've addressed the key issues, so thank you very much. No further questions. Thank you. Thanks, Ms. Ryan. Very good. Okay. Right, Mr. Sternberg's sitting there, and we've got your statement too. Well, thank you very much. We'll proceed with that. Yeah, sure.
My name is John Sternberg. I hold the position of Engineering Manager with TKO Tauranga. I hold a BSc Civil Engineering degree and a Master in 3 Waters Engineering. I'm registered as a chartered professional engineer and have about 40 years experience in 3 Waters Engineering, predominantly water and wastewater, for land development, local government, and private sector. My evidence addresses the original water and wastewater assessment, getting updates and changes to that assessment as appended to my evidence. My response to the water and wastewater management raised in submissions and my response to wastewater management raised in the Central Target District Council Plan Section 42A report. Just a summary in general. Proposed Rocky Point development includes 30 lots to mix with residential, large residential and communal use. CCAL's assessment for the treatment and disposal of wastewater as well as the provision of water supply options is summarized below. Service agency agreement will be established to ensure the ongoing maintenance of all water supply and wastewater infrastructure, including monitoring and reporting in accordance with Water Services Regulator, drinking water quality assurance rules and requirements for acceptable solutions for mixed use rural water supply. With regards to water supply, it is proposed that the water will be supplied to the proposed development from Chinaman's Terrace Water Scheme. The scheme draws water from an existing bore to the north of the subject lot with a permit to extract 2,735 kilolitres per day from the aquifer and culminates in 4 elevated storage tanks to the east of Rocky Point. All water quality is generally good. It has been tested with no or little pre-treatment expected. Treatment at point of use through filtration of the water is however proposed. That for example, that the households can ensure that the provision is safe, treated water in accordance with the NZ drinking water standard requirements. The estimated total water demand for the developers is 22.5 kilolitres per day, based on 30 lots, an average of 3 people per lot, and 250 litres per person per day consumption. It's proposed to expand the existing bank of water storage at Chinaman's Terrace at a suitable location to provide sufficient storage and supplementary harvesting of rainwater on each lot will be considered as a water conservation option for localized irrigation purposes. Wildfire Management New Zealand have provided advice area of land for land disposal, not considered feasible given the geology of the site, or discharge to the Pluto River, considered ecologically and culturally sensitive. The selected option was considered to be the most versatile and practical solution with the least environmental impact.
Thank you. Thank you. We just see if we have any questions now. And did you have any on those sort of side of things?
The dispersal of the treated waste, will it follow the same flow paths as the stormwater?
The waste water will be dispersed to ground and land disposal. So there will be specific land disposal beds designed adjacent or near to the treatment plant. And it will be treated to the secondary level of treatment and disposed into the ground. So recharging groundwater.
And sort of so,
So it's effectively a perforated pipe embedded in the ground, slightly above or slightly below, and wrapped in a geofabric and permeable sand. And the size of this pass is about 1,100 square meters to discharge the treatment effluent into that pipe network where it permeates through the perforation and into the river.
Is that okay, Ian? All right. Just in relation to the water take on your page 7 at the bottom, you've referred to a permit's been given to extract a certain volume of water from the aquifer, referred to as the Chinaman's Water Terrace Scheme. You said it's intended that water should be supplied to this. Is that all locked down? Because I took Mr. Brown's evidence to be saying that that's all secure. Or is there still a process to go through to get that water?
As I understand it, the 500, I think the aquifer, the permit to withdraw from the aquifer is about 1,275 cubic a day. Of that, 500 cubic meters or kiloliters.
Yeah.
Is for the Bendigo and Rocky Point and China scheme.
So it's secure.
Yeah. Part of the component is quite small compared to the overall component. That's key.
So there's no problem with the water. It's all locked down. Okay, that's fine. So one other question, I don't know what that was. 32, your paragraph 32A, you've just commented on the section 42A comment on provision of 3 waters, electricity and telecommunications. And all lots can be catered for from the proposed bulk storage, fire hydrant, domestic tanks. However, this consent condition could still apply. But I think I just questioning whether that condition is still required. Probably a question for Mr. Brown, but when we go through the conditions with him, do you think that condition is still required?
Under the current design, all lots can now be serviced.
Yeah.
FW2.
Right.
That's the SNZ.
Oh.
With five hydrants. So there's no specific need on any of the lots.
Okay.
On site 5 meters.
Okay, so there's no problem there. All right. And it looks like Fenz's concern has been met. That's your paragraph 20. They certainly haven't highlighted any outstanding concerns, so that looks like that's taken care of. All right. Unless you have any further comments, that's it. We've got no further questions. Thank you very much. Thank you. It's the servicing. Okay. All right. We'll take a brief adjournment. Has anyone got any thoughts on whether we do a site visit this afternoon? Does that affect anyone at the stage before we see if we've got a car and that sort of thing?
That availability in the morning, I guess, the apologists.
Oh, okay. Yes, that's right. We'll take a break. Have a break and do that. Yeah, it's not paramount we do it now, but we would need to. We could do the ecologist this afternoon. It doesn't matter. Oh, by the way, whatever suits really. But, yeah. Okay. Yeah.
So, what, 5 minutes?
Yeah, 10 minutes. We'll come back in 10 minutes and that's fine. Okay, we'll just reconvene the hearing. We were going to discuss the panel doing the site visit this afternoon. Excuse me, we're just is doing some housekeeping. We're the panel's ready to go to the site. We have a car booked for that. And if does that suit the applicant? If we do that, we would like one of your team to come along, and Mr. Vincent will be there as well to counterbalance. And we're not going to be talking about merits of the proposal, just pointing out where things are. So just want to make that very clear that that's all we'll be engaging with.
Yeah,
Is that okay?
so, you know, we agree it would be useful for the panel to get out on site earlier than later. And
Yes.
put some context to the ecological evidence.
That's right.
Before it's read.
Yes.
So, Mr. Brown can be available for site visit this afternoon, but also needs to work to fine tune these conditions. So if it's a matter of just orientation.
Yeah, I mean,
Either be Mr. Gall or
yeah.
Mr. Brown, but if you prefer two planners, then.
I'm fairly open to it, and there's also Department of Conservation to consider as well. Have you got any thoughts on? Would you like to be represented on the site? Because we're really just going to familiarise ourselves with the site. We're not doing a detailed site survey or anything like that. But are you happy for? Yeah.
Have you got your own train? Because we're only going to Rev will only hold 5.
We're going to have 5, but I'm just thinking in terms of the applicant's point of view. If Mr. Brown is busy doing conditions and it's just an orientation thing, how would you feel about someone from DOC coming, or are you happy just for us to all go with the officer? You're happy to?
Yeah,
Yeah. I'm happy with that. Just to make it absolutely clear, it is just orientation, and it'll free up Mr. Brown to do some work on conditions. So that might be a good outcome. Are you okay with that, Mr. Ewens, or would you still like to? Yeah, I mean, it'll just be the officer and Mr. Garden, who knows the site probably better than anyone. Would you be okay with that?
I only come with this.
no,
No, that's right. Well, yeah, I mean, we're certainly only just going to look at features, and I mean, Mr. Vincent, you've been up there several times, haven't you? You'll know the lie. He'll know the site well enough to be able to show us where things are. But it could be argued that we don't need anyone else. We could just have Mr. Vincent if everyone's comfortable with that. And then there's only 4 in the car instead of 5. Okay, we'll do that. We'll do that, Mr. Garden. Yeah, thank you for the offer. The gate was open last time I was up there. I presume it's still open. Yep.
Closed last night.
It closed last night, so we just opened it ourselves.
Just
Okay.
Just the wire.
not particularly sophisticated, no.
Well, that's what we'll do. If everyone's happy with that.
Thanks,
Okay.
yeah, so tomorrow morning we'll be back on at 9 with,
Yes.
the 2 ecologists,
Yes,
visit management, and then Mr. Brown
that's right.
and conditions.
That's right. Yes, that's what we'll do. We'll start at 9, and if we do finish that before lunch, we'll start with Department of Conservation. So we'll make sure we get through them before the end of the day, and also anyone else. I think one of the other witnesses is not appearing. That's
Yeah, he's back.
Oh, Mr. Lister, but also one of the submitters is not appearing. I believe it's Central Otago Lakes Branch Forest and Bird are not attending. So I believe we were told. So yep.
Who are you saying?
All right. Well,
And one final thing, sorry, so I will be in a mediation in the morning for about 2 hours, so Mr. Grissom will do
Oh, that's fine.
shift and I'll came up.
I'm going to excuse myself and go home because I don't think leather-soled shoes are appropriate.
all right. We'll adjourn for now and reconvene at 9 a.m. So thanks everyone for your involvement today. Thank you. We'll see you tomorrow.